Good afternoon, everyone. Welcome to the Appellate Division First Department. Oral arguments for today, October 1. So please, as you know, please only ask for the time that you actually need in order to get out the salient points of your argument. We have about 6 hours of argument time requested. Please keep in mind, we've read your briefs. We're fully aware of your arguments. If additional time is necessary after the light goes off, it will certainly ask those questions. People v. Vincent Hanneman. 424, AIG Property versus MTS Power Systems. Five two five. Matter of Tariq M. That matter is submitted. Geoffrey versus O. I know, I was looking around also. I don't see an appellant. Did you wish to submit or did you wish to argue? Sure, 3 minutes. Rodriguez v. Riverside Center.
Respondent, 5 minutes, please.
525. Corrects v. 363 East 76th Street.
7 and 3 for appellate, Your Honor.
Likewise for the respondent, Your Honor, 5.
625. People v. Jose Perez.
Respondent requests
212. State Farm v. Equinox Physical Therapy. I don't know. What do you want to do? Sure, 3 minutes. Landa v. Friedman. 626. People v. Angel Ramos.
5 and 2 for the appellant. 4 for respondent.
524. Bapaz NYC versus Asa Properties.
5 and 2 for the appellant, Your Honor.
Your Honor, 7 for the respondent.
Certainly. 525. Porter v. Bachner.
6 and 2 for the appellants.
525. U.S. Bank v. Marv Hotel.
5 and 2 for the appellant, Your Honor.
5 for the respondent.
525. 609 Realty versus New York State Division of Housing. 523. Tamanius, I'm apologizing, versus Zomic. That matter is submitted. Justice O'Neill Levy is recused on that matter. Acosta Romero v. Fong. That matter is submitted as well. First case for argument, People v. Vincent Hanneman.
Good afternoon, Your Honors. May it please the Court. Sarah Chaudhry from the Legal Aid Society for Appellant Vincent Hanneman. Your Honor, Mr. Hanneman is before this Court seeking a reduction of his post-release supervision term from the maximum of 3 years to the minimum of 1.5 years. Although there are many factors that augur in favor of this reduction, the primary basis for his request is situated in the principle of proportionality. So although Mr. Hanneman was not by any stretch of the imagination the key or pivotal architect of this wide-ranging investigation into a criminal drug conspiracy,
Wasn't he the major supplier?
he was not the major supplier, Your Honor. In fact, nearly 7 months before he was implicated in the conspiracy, 9 drug sales had been made, one of which was for $6,000 of heroin. The sales that Mr. Hanneman allegedly supplied, the two of them together were approximately that amount.
Yeah, I noticed in your brief you talked about the fact that he had only been involved in 2 sales, which was interesting because the people in their brief stated that this had been an ongoing conspiracy and ongoing sales wherein he was the major supplier for over 2 years, and that he had supplied to at least 2 undercover officers in the 2 cases that you mentioned. So it seemed to me that you kind of, to some extent, minimized his involvement in this ongoing drug conspiracy.
I understand, Your Honor, and I think that the prosecution's assertions that he was involved for 2 years It's not predicated on the indictment. It's predicated on a statement that may have been mentioned in the PRS of Mr. Hanneman saying something like, I had been selling drugs for
I
this
thought it was
period of
more than his statement. I thought it was actually what had been uncovered by the pen registers, et cetera. Also, you talk about proportionality. I had never seen this before, where the argument is that you combine the total term of incarceration with that of post-release supervision, and because that number is now greater than what the other defendants time added up to, that therefore it's a greater proportionality. But I noted that the other defendants, and please correct me if I'm wrong, they were not preds, were they? Predicate felons, were they?
Your Honor, some of them were predicate felons.
And they had been involved to the extent your client was involved?
In fact, more so. Mr. Ildefenso, who was involved in 9 sales prior
Post-release
to...
supervision did they get?
So Mr. Ildefonso received 3 years. However, he received only 4 years of incarceration. Now, with respect to your comment, Your Honor, I think it's well taken that why are you combining these two things?
Yeah.
The fact of the matter is, the sentence is both the term of incarceration as well as the PRS. If we're just looking at the facts of this case, the fact that he was not...
We're looking at that, wouldn't the appeal waiver, in essence, preclude the review of the sentence, including the PRS?
So there's two things to that, Your Honor. One, the appeal waiver in and of itself was completely erroneous and defunct, even under this court's precedent of people being
How?
Francesco.
Why?
Because when the court took Mr. Hanneman's plea, it stated that by pleading guilty, he was forfeiting any challenges to the suppression hearings. We all know that that actually happens with the appeal waiver. But so that's one thing. Secondly,
I didn't see that. Was there a specific statement by the court stating that you're forfeiting your rights to appeal the suppression issue?
that's right, Your Honor. The court made an explicit representation, and in fact, the prosecution has waived any argument they may have with
They
respect to
don't
the
make an
appeal
issue of
waiver's
that in their
validity.
brief, do they?
Sorry?
They don't defend the appeal.
They don't. So they've waived that argument. They don't brief it at all. So I think their non-briefing is a concession that the appeal waiver here was invalid. Now, I know I'm almost at time, so I
I
just
don't know if
wanted
they
to...
conceded it, but they didn't defend it.
They didn't defend it, so they forfeited it. They waived it. They waived it by not including it in their brief other than, essentially putting in a footnote saying, we're not going to contest it, but either way, the substantive claim should fail. Okay. Well, I can reach the other arguments, Your Honors, on rebuttal.
Thank you.
Good afternoon, Your Honors. Jamie Maston for the people. In this case, we are not relying on the waiver, but in any event, the sentence here was fair and appropriate. And there are 3 reasons that directly counter the defendant's claim that his
The other defendants were less culpable. The other defendants got less time because they were less culpable.
There are a variety of factors as to why the co-defendants received what may look like a combined sentence of less time than this defendant. Only 2 of the defendants, including the defendant here, were violent predicate felons. The other violent predicate felon pled to a D felony, not a Class B felony, which this defendant pled to here. The rest of the defendants, if they had a predicate status, were non-violent predicate felons, which drastically lowered their sentencing exposure. So in this case, this defendant, as seen by the extensive indictment, had an active and integral role. He basically supplied, as Justice Schulman said, the individuals who later sold these quantity of narcotics to an undercover. And these were very large amounts. On one date, it was 65 grams. On another date, it was 2 ounces, which the undercover later purchased for thousands of dollars. So this defendant was moving a large quantity of narcotics in relation to this conspiracy.
He was responsible for the selling of more than 2 ounces of cocaine.
Yes, yes. But he certainly admitted that he had sold 2 ounces of cocaine in his plea colloquy. And as we can see in the indictment, his involvement was very extensive here. That
So
alone,
is your reliance on, or your statement that the defendant engaged in this activity of supplying drugs for over a 2-year period of time, was that based upon the defendant's statements, or was that based upon something else?
it was mostly based upon the defendant's statements. He admitted to the Department of Probation in the PRS that in addition to his day job, he had been selling narcotics basically on the side for over 2 years. So it's the combination of what was laid out in the indictment under the overt acts with his own admission that he was selling and supplying these narcotics. But it's this idea that the defendant got a disproportionate sentence doesn't really hold water once we look at what's going on behind the numbers.
Would you agree that at the end of the day, under the Less is More Act, the defendant on good behavior could actually reduce his time under the PRS?
That's exactly right. And
So it could actually moot all this.
exactly. This defendant is the type of individual who should be incentivized to earn exactly what he is asking for by this court through his good behavior. And in addition, the disproportionate argument doesn't hold water because this defendant received the lowest possible prison term he could have as a violent predicate. And the three...
Did the sentencing court have all the mitigating factors that were mentioned, the mental health issues and drug use issues?
And his employment status, yes. The sentencing court absolutely had that in front of them in the PRS and took that into consideration when fashioning this sentence. The 3 years of PRS that this defendant got was in no way disproportionate to those of his co-defendants. It was either identical to or only 1 year less.
Well,
1 year more.
one defendant, I believe, I don't recall which one, did get 3 years post-release supervision as well, but only, I think, 5 or 4 years incarceration, maybe 5 years incarceration.
Yes, what's key here between this defendant and the others is that, like the defendant, for every defendant who got post-release, they each got the maximum term possible. But unlike this defendant, they all received prison terms above the minimum. For that reason, the disproportionality argument simply carries no weight here, and we'd ask this court to affirm. Thank you.
Thank you.
So I'm just going to make 3 points in rebuttal. I don't want to spend too much time on the first point, which I think that the indictment bears out, which is that Mr. Hanneman was not the key or primary architect, regardless of what the prosecution has said. Mr. Ildefonso, Mr. Faustin, Mr. DeVito engaged in large amounts of heroin sales for 7 months prior to Mr. Hanneman being involved here. He had these 2 discrete sales. Secondly, with respect to the Less is More Act, Mr. Hanneman has been doing great post-release, and he's been having his sentence reduced every 30 days. However, the fact that the act has been passed doesn't preclude this court from taking it into consideration and also determining whether or not the sentence that Mr. Hanneman has received is appropriate. So as of right now, Mr. Hanneman has served nearly 1.5 years of time on PRS. He will be released in April 2025. That doesn't make this a moot point or not important for this court. PRS is significant, it's punitive, and in this instance, there was too much of it.
Well,
Another point that I
given his substance abuse issues, I think I read that he had never received any type of substance abuse treatment while incarcerated. So given his substance abuse issues as well as his mental health issues, isn't post-release supervision a good thing? And also given his history of selling drugs as a means to make a living, isn't this again something that is necessary in order to assist him?
Well, Your Honor, I think that you're right in terms of how much time does he need. The Less is More Act is predicated on an understanding that too much time is actually counterproductive. Even ADAs and DAs have agreed that 1 year is an optimal amount of post-release supervision time. Now, just to bring Mr. Hanneman back into this picture, Mr. Hanneman started abusing drugs at 11. 11 is elementary school. 11 is a child. He's been diagnosed with bipolar 1. This court, on numerous occasions, has taken a look at a situation like this and said the overcriminalization of people with mental health issues is wrong. Respectfully, I know my time is up, but I would submit that Mr. Hanneman is someone who's deserving of a reduction, given the 3 primary factors here that resulted in him receiving a sentence that's above what he should have received.
Thank you. Thank you both. AIG Property versus MTS Power Systems. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Joe Federici on behalf of Appellant MTS Power Systems. Your Honors, we are here because we believe strong sanctions are appropriate and necessary for AIG's complete and total spoliation of all evidence of interior damages that they now sue to collect on. Disposal of this property precludes MTS Power from ever having a chance to inspect the property by themselves and by their experts
Did they not give you an opportunity to inspect the property? Didn't they give you notice as to what was going on and therefore an opportunity to inspect the property?
So AIG gave MTS Power the opportunity to inspect the generator that was on top of the roof. This was a fire origin and cause investigation. This wasn't a property investigation. MTS Power had no idea that AIG would be claiming there was extensive damages all throughout the house. MTS Power's expert timely made a request to inspect the property, and AIG ignored it. And during this time, AIG had its own experts examining the house, making lists of property, basically simultaneously with MTS Power's experts' request to inspect.
So at some point, is it Barry Siegel of MTS was contacted March 2018 by Sullivan, who I'm assuming, is from AIG, asking him to send your liability adjuster. Sullivan is a female, to send your liability adjuster, and then she follows up a couple hours later stating, before there are any plans to remove the evidence from the roof of the home, the liability carrier, you should be involved.
So at that point, the MTS Power already knew about the fire. They found out about it from a plumber. MTS Power went to the house. MTS Power notified their insurance adjuster. The insurance adjuster notified the insurance company, and the insurance company assigned a general expert adjuster who, at the end of March, reached out to AIG's subrogation attorneys and requested to inspect the property.
So that's on March 27th, 2018.
Correct.
Quaratola contacts Sullivan of AIG and asks about the status of the inspection and repairs. And Sullivan only responds about the repairs. So why didn't Quaratola follow up about an inspection?
Your Honor, we admit that Jerry never followed up, but the duty to preserve evidence isn't created by multiple demands to inspect the property. The duty exists when a party knows or should know that the evidence might be used for future litigation. So here, AIG had its subrogation attorneys on the scene right away, and MTS Power had no idea that this would turn into a $6 million
What
claim.
evidence do you say, what specific evidence do you say is missing?
Your Honor, there is no evidence in the record, there's no objective evidence that shows any damages inside the house. We have pictures. None of the pictures show any damages. We have lists of property that is considered part of the claim, but nowhere in the record are you going to find any descriptions of any damage to any property. Nowhere are you going to find any objective testing that was available to AIG, such as testing for the byproducts of combustion, smoke mapping, chemical
So
soot
do we know
sponges.
for a fact that that evidence existed?
Well, the evidence was to be collected by experts on the scene, and AIG's experts didn't collect it. All three of these experts had industrial hygienists that they typically use to establish the scope of damage, and here they just didn't use them.
You weren't denied a sanction here. It's just been left to the trial court to evaluate things and make a decision about this at that time.
Your Honor, the only issue that was expressly deferred to the trial court was our request for an adverse inference at trial. We had to appeal this decision because the lower court stated that we failed to establish severe prejudice from the spoliation. So the court also said that it's an open question because discovery is still open, but discovery is closed. So if the lower court can look back at this decision and say, oh, well, we decided it, discovery was closed, the issue was decided, then we had to appeal it, and the appeal is properly before this court.
But you moved to dismiss the complaint.
Correct.
So isn't that rather drastic under the circumstances, under the facts presented?
Your Honor, MTS Power's affirmative defenses are already stricken. MTS Power's experts are already precluded from testifying. Basically, this would be a one-sided trial where AIG's experts will testify the entire house was destroyed, even though there's no real evidence of it that's objective. And MTS Power is left with nothing because AIG dropped the ball and didn't schedule a joint inspection like what is done in just about every other case I've ever been involved in with property subrogation.
But AIG did not deny an inspection.
They never granted it. They never allowed it. They never scheduled it.
But as my colleague pointed out to you, you conceded here in argument that your inspector never followed up when he had a full and fair opportunity to do so at the end of March.
Your Honor, AIG could have preserved the evidence in storage.
That's not the point. Your argument is they paid out millions of dollars. Would you, being unable to determine whether they had to spend X, Y, Z for the type of renovations that they did to the home, you may have characterized it as simply soot damage, from the fire limited to the upper portion of the home as opposed to the extensive damage that was determined by AIG to pay out on this claim. You had a full and fair opportunity to go in and do the look-see, and you didn't. So how can you be hard to complain? At this point, you still have the opportunity to challenge any of their numbers of the work they did, don't you?
Your Honor,
you could look at the photographs, you could look at the repairs, you can bring in your own appraisal, you can bring in your own expert to say they paid out on this when they could have really paid less. You have that ability to do that at trial.
the best evidence is the evidence itself. There are means to test the extent of damage inside of a house from fire. Here, AIG's homeowner had special status with the company, and they paid her whatever they want. They paid her for a month's vacation to Italy.
Yeah, so again, you have the ability to challenge that as to whether or not AIG should in fact have paid her to stay in Italy for a month while the home was being renovated. But you have time on rebuttal.
Your Honor, I would just like to finish by saying...
yeah, that would be on rebuttal.
What's that?
Rebuttal.
Okay.
He's going to argue, and then you have time after that.
Good morning, Your Honor. Good afternoon, Your Honors. May it please the Court. Christian Sedarius for Respondent, AIG, at subrogee of Gail Siegel, Gortzman, Lefkowitz, Smith, and Sullivan. Just to the points that you already discussed, this
so
is
your adversary mentioned the fact that MTS is precluded from introducing certain testimony. Why is that?
That's the first time I'm here. There's nothing precluded. They're the ones that asked for preclusion in their motion against us and on the spoliation sanction for motions. As we said, that we believe that the motion is premature. There was a conference before the motion was decided where Justice Rosado asked about if she can defer the decision to the trial court. Appellant actually emailed the justice the case law, Butler v. Transit, which says she can exercise her discretion to defer to the trial court, who would be in the best position after viewing all the evidence as to what and if sanction is appropriate.
So discovery has been completed, has it not?
Yes, discovery is completed, Your Honor.
So there's no possibility of finding any additional photographs?
We've provided, as mentioned in my papers, appellant has had 6 depositions of the building consultants, the contents people. We provided all photographs that the public adjuster took, any photographs that were in the claims file, anything taken by the adjusters. As also pointed out, there was an opportunity for MTS representatives to get into the house. There was never a refusal. Barry Siegel, who was the owner, was on site on March 8th when they were removing the generator. Ms. Sullivan did ask for the carrier to get involved, which there was a slow response. They didn't get a response until March 13th. And then the adjuster who was supposed to come on site or asked to come on site was March 27, 2018, which they were still coordinating some things, but there were no follow-ups by Mr. Quattro to come into the home.
So essentially, you turned over everything that your claims file had and built up for this case.
Correct. And
the only thing that would be missing, arguably, I mean, if I could hypothesize a bit, is let's say, I know couch was somewhere an issue in terms of being damaged. So if they had to throw out the furniture, for example, their position will be, well, gee, how badly damaged was the furniture? Because we would have liked to see the furniture and know how badly it was.
Correct. That's correct, Your Honor. And there are appellant has the ability to get an expert, they can review everything that we've given him. There was nothing in the papers stating why they're prejudiced, why they're not unable to do
What
this
about the
work.
generator itself? Were they precluded, or did they have the opportunity to inspect the generator itself? given
Yes, the
fact-
generators were preserved along with, there were two generators, the one where the fire started, and then there was I forgot the word now, the other generator. They took both, they had to take them down by crane, and they did have a site inspection of June of 2018. At that time, Ms. Sullivan was still actively talking to the carrier, letting him know, coordinating that. At no time did anybody say, hey, we need to get in the house and look at the damages. The repairs were going on from the testimony up until September, so that's 6 months that went by that nobody ever followed up from MTS to say, hey, we need to look at some of this damage.
On this record, did they take a position on the generators, that it was an act of God as opposed to being a defectively
No,
installed
there's
generator?
no issue as to liability as of right now, so, I mean, that's an issue for trial, so. And there is a duty to mitigate as well. They can't just let everything sit around. I mean, there was a fire department came in, they did spray down the house, things turned to mold, so you do have to start making repairs to the home as soon as possible. But at no time did AIG ever refuse anybody to come into the home. As I said, MTS was there from the beginning. And we feel that their burden of proof hasn't been met based on the ability to preserve, that there was no negligent spoliation of the evidence. And I know you keep saying, hey, they could have taken it. I mean, we're talking about walls, ceilings, carpets. They're not going to preserve walls, ceilings, and carpets. You have to come in, and he had the opportunity to see those in photographs. The appellant had many depositions of the AIG adjuster, 2 of the building consultants, 1 of the contents person. The insured came down for a deposition. He also did the public adjuster. So what else? The case law actually states that when you have other means of evaluating the damages, you can do that. Your spoliation sanctions are inappropriate. And in the cases all cited by appellant, all the cases that point to spoliation are based on causation. It has nothing to do with damages. So, and based on that, that's it.
Thank you.
Thank you.
Your Honors, the applicable case law by this department, 430 Park Ave versus Bank of Montreal, and Fraser versus 301-52 Townhouse Corp. state and hold that joint inspections are necessary to avoid a one-sided trial, and strong spoliation sanctions, such as dismissal or preclusion, are appropriate if joint inspections aren't scheduled. Here we have a very dubious fire claim. There's no way MTS had any idea that this would have ballooned into what it was. AIG clearly had the duty to preserve the evidence. They should have gone out of their way to schedule a joint inspection of the property, like they scheduled the joint inspection of the generator.
They attempted to schedule an inspection. They reached out to you to inspect the premises.
That never happened. Only the generator removal, that involved going to the roof and removing the generator with a crane, and then later on, in June, it was inspected off-site in New Jersey. So please don't confuse the inspection of the generator with the inspection of the property.
Where does your preclusion come from?
Your Honor, that was really just an argument that basically MTS is precluded from having expert evidence because our experts never had the opportunity
So there's
to
no
examine
order
it.
precluding you.
No, there's no legal order,
Oh,
but
okay.
it's just a fact of how AIG handled this scene. And basically the spoliation was, happening almost instantly, and AIG's experts were at the house the day after or the day before MTS Power's experts said, "Can I please see the property?" They should have said, "Come on over." Instead, they said, "We'll get back to you," and they never did. So this is fair, and it's inequitable, and it's going to lead to a one-sided trial, and the law
And
of
there was
spoliation
there
doesn't
was-
allow that.
There was nothing incumbent on you or your inspector to say, "I'm still waiting." You said, you'd get back to me. Why haven't you gotten back to me?
That would have been good, but we can't read AIG's mind. They knew, they were on the scene, they knew what was happening. We
Would
didn't.
that be reading their minds? I mean, they said, "We'll get back to you," and they never did. If somebody says, "I'm going to get back to you," and, they tell me that, yesterday, I'm calling them today, especially something like this.
That would be the best practice, but AIG has the primary duty to preserve evidence, and this is the worst spoliation I think I've seen in the case law that I've researched.
Thank you.
What about the argument that counsel makes that the nature of the damage, the ceiling, the walls, that can't be put in storage?
No, but what is typically done for property subrogation, if there's a fire claim, is they test for the products of combustion with a little test and a swab, and they can do smoke mapping to determine the extent of any damage inside the house. That is what's typically done for property claims, and they avoided doing it here. Instead, they said, well, we established the scope of the damage, and we made lists and measurements of the house to pay the claim.
So would that not be your argument at trial?
That's an argument, but it's not real evidence. We're left without the evidence. If we would have had our expert there, he would have done these things, and he would have said, this is exactly how much damage or how much there is or isn't in the house, and this case would have been settled 5 years ago.
Thank you. Thank you both.
Thank you.
Jeffrey V. O. Yes, you may proceed.
Thank you. Thank you, Your Honors. My name is Kathleen Thomas for Thomas Counselors at Law for the respondent, Ms. Virginia Giuffre. Good afternoon, and may it please the court. Based on the appellant's own pleadings and the documentary evidence provided in this case, it is a legal impossibility for the appellant to state a cognizable cause of action. The appellant in this action, as a defendant bringing counterclaims in Ms. Giuffre, asserts one occasion of sexual assault. And in the very pleadings in this case and in the federal case, Jeffrey Epstein was present and also directed these acts. Ms. Giuffre, the respondent in this matter, proffered documentary evidence from the U.S. District Attorney's Court, Southern District, that she was identified and labeled a victim of Jeffrey Epstein. So this matter is not about how the appellant shaped it, that this is a civil case. We need to look to see if the civil matter is going to be based on criminal liability. That's not the issue. You don't even really need to do an analysis on the Adult Survivors Act. These are only intentional torts. There's no negligence causes of action being brought. There's no entity. The intentional torts are impossible because this respondent, Ms. Giuffre, is identified as someone who lacked the agency. She cannot be a trafficking victim by the district court unless she is found to be forced, coerced, or fraudulently induced to commit the crimes. And these crimes were at her trafficker that has been named. And so the respondent asked that the court should affirm the lower court's decision and granting respondents' motion to dismiss this matter as a matter that does not even need to reach the fact finder. And I yield the rest of my time unless the judges have any questions.
Oh, thank you very much.
Thank you, Your Honors.
Rodriguez v. Riverside Center.
Good afternoon. May it please the court. Payne Tadich on behalf of the defendant's appellants. The Supreme Court erred in granting plaintiff summary judgment under labor law sections 240 subsection 1 because at the time of the accident, plaintiff was engaged in routine cleaning of his employer's truck, which is a type.
Was it routine cleaning, but it was really incident to the actual covered work of delivering cement at the construction site? Did you hear that?
Yes, I did.
So, I mean, in a sense, it's not like he took the truck back to the garage and hosed it down for the night. He had to keep that chute clean in order to allow the flow of cement to properly be poured at the work site, correct?
No, I actually don't believe that that's correct. I think it's a little bit more nuanced than that. So taking the last part where you're saying he had to keep it clean in order to have the cement pour through the chute. Plaintiff actually testified that at the time of his cleaning, he had no idea whether he would be coming back to this project. He didn't get his assignments on the job until he went back to the yard And he testified, and he said this pretty succinctly on, this is 1197, the record. If it weren't for the accident, perhaps they would have sent me locally or to another job
How many
site.
times had he been at that site that day?
He had been there twice prior that day.
That day.
Yes, that's correct.
So would it be more likely than not, given the fact that they were pouring concrete at that site, that after he finished, he most likely would have been returning to that site?
I can't answer if it's more likely or not. I believe that's one inference that a jury could decide based on his testimony that he didn't know where he was going versus the fact that he's been there twice before on that day. And, you know, to this point, he had testified previously. He'd done work somewhere else on that block. He testified when he was asked what were your duties and responsibilities on the date of the incident. He said delivery to several places. That's 1196 in the record.
Because he delivers where Jenna tells him to deliver, but they had a contract with Sobara that they were going to be providing the concrete for that particular project.
Yes.
That day, he and others were doing exactly that.
Yes, that's correct, but he might have been sent to another location, and he testified very clearly to that. He states at another point, this is 1209, they asked, you don't know in advance if you're going to have more work that day? Answer, no. So he might have also gone back and parked the car in the truck and gone home for the day. I believe that the...
But if you deliver cement, don't you have to clean the truck? Isn't it part and parcel of the delivery?
I believe that you have to clean the truck because if you don't clean the truck and the cement is allowed to harden, you're going to ruin the truck. And that is routine maintenance under this.
Let's be more specific. Not so much you have to clean the truck, you have to clean the chute from where the cement flows from.
That's correct.
So that's what we're talking about. We're talking about cleaning the chute. So as my colleague had stated previously, is that not incidental to the work that has to be done? Because if he's delivering the cement has to come out of the chute, and if the chute is dirty or the chute is clogged, the cement's not going to be able to come out of the chute.
It might be incidental, but I don't believe it's necessary. And under the court's precedent and the...
How would it not be necessary? I'm not understanding why it would not be necessary to have a clean chute and a chute that's not clogged in order to have the cement come out of the chute.
Well, the issue here is what type of work plaintiff was performing at the time of the injury. The time of the injury, he was cleaning the truck.
But you called it routine maintenance of the truck, and that's true. You could look at it as routine maintenance of the truck, but it's not routine maintenance in terms of the job you're doing, which is delivering cement to the construction site. You want to separate the truck from the job, but bringing cement to the job is not routine.
But
the cleaning is taking place at the job.
Yes, and it was performed after he testified he completed the delivery.
He also testified that he had been directed to the cleaning area by one of the individuals at the site.
He had no communication with them. He spoke.
I thought he said that they had directed him. I don't know whether hand signal was used or what, but I thought in his testimony he said he had been directed to the cleaning area, and he went to the cleaning area, and that's where this occurred.
There was a flag person on the job.
Okay.
But that doesn't change the routine nature of what the work was doing or the reason he was doing it to...
Can I ask you a silly question?
Yes.
Are you seeking reversal of the lower court?
Yes.
So in other words, the lower court found that it was routine maintenance and therefore not covered by Labor Law 241. Listen, that's what the lower court found. You're here arguing that it's routine maintenance. Why are you here?
No. The lower court found that this was a continuation of the concrete pouring. And our argument is that this was routine maintenance that is not covered under the statute, and it's not the type of activity that the legislator intended to impose liability for. And we rely on two other cases with very similar facts.
You're able to make that argument because you're separating what the truck is doing in terms of cleaning the chute, which, yes, cleaning the chute is a routine activity, but bringing the cement to the job site is not looked upon as routine maintenance because that's part and parcel of the construction process, and that's not routine.
Well, our argument is that because he did this after he testified he completed the delivery, it's not necessary to the erection of the building. The construction work would continue regardless of whether he did his washing activity. I see that my light is on. I can continue.
Yes,
the
you
rest
have
of this
time
on
on
rebuttal.
rebuttal.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. This is covered under 240 because you have to take it as a case-by-case basis and look at the context of the work. And this is a continuation of the enumerated activity of construction. And plaintiff did testify that he was instructed by a Sabara worker to clean the truck 10 feet away at a wash box. That's at 212 of the record. So we know that mixing, pouring cement, that's covered under construction under the labor law. So plaintiff was on a continuous loop. As he testified, he would mix the cement, go to the site, load the truck, pour the cement, and then he'd have to wash it and to bring it back to Jenna Concrete before he knew if he can go back out again, which he did 3 times that day. He testified he already cleaned the truck twice. So in order to do that, it required him to wash the truck.
From your perspective, it's a little bit like going up the ladder is a covered activity under 241, and going down the ladder is also a covered activity under 241.
That's correct. It's part and parcel. You can't separate the two. Our position is that you can't separate the two, just like the trial court in Martinez did, and just like the Second Department in Dalta did, where you can't separate the two because they're part and parcel of the same enumerated act.
It's required. You have to wash the chute. You're
Correct.
not going to leave with the chute dirty. It's required. You have to wash it after you deliver it.
That's correct. And actually, there's nobody was ever asked why. For example, their argument is that you have to do it to preserve the truck. Well, no, you have to do it in order to go back out to deliver more concrete, which is part and parcel of the construction project.
So that was going to be my question. Why did Sobara provide the wash box?
The whole point
Because they wanted to move the project.
Correct. It's part and parcel of the cement delivery in the construction process. And also, as we know under Pratt and Saint, that you don't isolate the moment of injury, right? You never, Saint says, don't compartmentalize and, and exclude preparatory or post-enumerated act if it's in connection with it. And in addition, I also think that this meets the SOTO factors of cleaning. The factors of SOTO, it's in our brief, and you know what they are, but this doesn't occur in a recurring schedule that's part of maintaining a premises. It also it involves elevated risks that aren't comparable to domestic cleaning, and it requires specialized equipment, which is a power washing hose. So under SOTO, this is cleaning. To me, it's a standalone. Even if you don't look at it as in the context of construction, which I think it is, it's also a standalone cleaning under the labor law. So so once we get past that, this is clearly an elevation-related risk. This is a 10-foot fall. There's a railing that broke. It's on the floor. The picture just says it all of the truck. It failed to support him. And do you want me to address 241.6, or would it be rendered academic? Okay.
It would be rendered, right?
I'm sorry?
It would. Do we need 240?
Well, no, I mean, no, it's just that, no, we don't need to. I think that it speaks for itself. Okay, thank you for your time.
Thank you.
Addressing first the claim that he was instructed by the defendants to wash the box here. The testimony is clear. The only person he ever spoke to at this site was the pump operator, and that was when he obtained the signature saying, this job is done. He didn't speak to anybody of the defendants. It was just a flag person. I don't believe that that's instruction under the law. And yes, Sabara did install the wash box. The inference they have here is that it was required of him to wash the box. I read that as, we don't want you washing off your concrete onto this site, which would be an environmental hazard. Obviously, there are two different inferences from that. Again, I believe that's a jury.
Could he have gone back to his shop and washed the truck there?
Perhaps he could have. Now, I'm not going to comment on the wisdom of that, but perhaps he could have gone back and done it, or he could have gone and done it somewhere else on site.
But he was directed or guided to go to a wash box that was 10 feet away from where he had just delivered the concrete.
Correct, rather than somewhere else on the site where it would pose an environmental hazard. And the plaintiff's argument...
If they didn't have the wash box there, we don't know if he would have washed the truck somewhere in the project.
That's correct. And they're talking about this requirement that he did it. Well, their whole argument up until this point was been that his boss required it, not that the defendants required it. And going back to the activity itself, even a cleaning activity or something that would be a continuation, if it's a routine activity that involves minimal work, minimal tasks, and it doesn't rise to the level of a statutorily protected activity, and that's what we had here. He performed this 20 to 25 times in the week before his accident. It took him 5 minutes to do this activity.
I
He
don't
only
think it's
used a
time
hose.
sensitive, or temporal. It could be, as you say, routine, but here it was an incident to the construction work of getting this cement. I mean, there's precedent for this.
It occurred after he completed, and so looking at the time of his accident, it's correct that we don't isolate the moment, but we still don't strain the statute to include that which wasn't intended by the legislature. So I believe at minimum there's issues of fact on this record that a jury should be allowed to consider.
Thank you.
Thank you.
Peretz v. 363 East 76. Yes, you may proceed.
Good afternoon, Your Honors. Jeffrey Metz for the appellant. I'm here today asking you to reverse the order appealed from and reinstate the first and fourth causes of action in my client's complaint. Now, Your Honors, I believe that the key focus here is the language that was contained in your first order on this, where you return this case back to the trial court to permit the introduction of extrinsic evidence, and here's the key words, to discern the party's intent as to whether plaintiff has the exclusive right to use the garden entrance. So what do we have here? We have on my client's side, you have the affidavit that is unrebutted, and remember, it's summary judgment. We have an unrebutted affidavit that he specifically negotiated with the board of directors to have this space, this private entrance space. You open up.
Well, that's the point, Mr. Metz, the private entrance space, not the surrounding courtyard where the ramp was built. So, and at the hearing, wasn't there a full and fair opportunity to flesh out the so-called ambiguity of what all the documents meant?
Well, Judge, the ambiguity is pretty clear because
I mean, entranceway means entranceway. It doesn't mean the whole grass and courtyard.
Judge, several points I have to respectfully disagree. First of all, this is consistent use for over 40 years, where that was used by Koritz, his staff, and his patients, not the co-op. As a matter of fact, the deposition of the president said that nobody used it, and more importantly, that there was no reason to put the ramp in there. There was no legal obligation to do this. This building was grandfathered. One second, I want to answer your question. I really do want to answer your question, Judge, okay? So you have private entrance space. My adversary says all that means is that it's a door. Well, we cite to you in a brief, just common language, what private means. Private means that it's exclusive to a party. Now, why would he pay, and why would anybody in their right mind pay a premium price for over 200 chairs to comparable apartments for a door, for a private?
Because this was a professional office space.
It is, that's true.
And that's what the evaluator stated in the evaluation.
The evaluator said, and by the way, that appraisal was not commissioned by my client, it was commissioned by the co-op, but they said,
says what it says.
They said,
It's a
you
document.
pay a premium because there's a private entrance and that requires more maintenance. Now, you don't need more maintenance for a door. Everybody has a door in this building. It's ridiculous to assume that he is going to pay a higher share price, 200 more than any comparable apartment, just because there was a door. Now again, unrebutted testimony.
That door has street access, right?
Excuse me?
It's street access,
Yes,
right?
that's correct.
So why not? Again, it's a professional apartment, a professional space with street access. So why not? Why would he not pay a premium for that?
Well, I agree with you, Judge, but that's fine. But that means that we get that space. It doesn't mean that we pay more and the co-op gets that space, because the supplement, Judge, the supplement said that we have the right to
Your
continue.
access to the door hasn't been cut off.
Well, Judge, you see, this is, okay, I agree. It hasn't been cut off, and I know Judge Cohen thought that was the case, but that's not the right way to look at this. He still has access, but that doesn't give them any excuse for usurping our property, for diminishing our shares and the value of our apartment. It's an apple and it's an orange. It's not the same thing. And the co-op had no right to declare that they could do this, especially when there was no emergency that required them to do so. They had two options to do this. Only if required by law, they conceded it wasn't, or it was an emergency. No emergency. There's no emergency here. And also, let's just take a look at the constant course of conduct, over 40 years. Now, my adversary will tell you, well, the inspection report is dispositive. That was done 11 years before he bought the apartment. It was done before the building was even became a co-op.
But was there a discussion of a courtyard in the appraisals or in any of the paper trail that was put before Judge Cohn? Did they say entranceway plus courtyard leading to the entranceway?
No.
They didn't say that.
No.
Parenthetically, just so it clears in my mind on this record, the unjust enrichment and attorney's fee counterclaim is gone.
Well, those are all dismissed.
And the private nuisance, your other second and third, just give me a second. Sure. Second and third claims for private nuisance and those damages. I know there was a stipulation withdrawing. Is it in? Is it out? Where are we at with that?
We're at, if you reverse, as I suggest that you should, those come back into play.
I see.
That's how that works. But look, they're relying on three things that have nothing to do with the fact that there was a negotiated deal here, that we got the whole area. They haven't rebutted that. The no action letter, which they used just because they wanted to monetize the space, that doesn't say it. The appraisal doesn't say it, and the inspection report.
I'm just curious, Mr. Matt, putting aside the unhappiness that the sign had to be moved, or when they looked out their window, they saw the higher walls of the ramp structures. Putting that aside, what did Dr. Koritz and his staff do with the grass and courtyards? They just came up the cement walkway to the office. Did they have barbecues there? I'm just curious.
No, they did not, Judge.
So they never really used the grass. They just used the walkway, which they still have today,
Judge,
yes or no?
Well, yes, but the question was that a negotiated space? Whether you used it or not, you paid for it. They paid for this. They paid for more than 200 extra shares at double the price. That's what they paid for. They should get the benefit of their bargain.
Well, the issue is whether they paid for that or they paid just for the private doorway, the street.
Again, I think we get back to this. To me, I'm sorry.
How do other
I
people
just think
get
it's
into
a
their
ridiculous
apartments?
notion that there's some premium for a private doorway. Every
How do other
door in that co-op is private.
Yeah, but
How do other people get to their apartments?
Yeah, don't they have to go through the lobby of the building?
So they go through the lobby and we go through the gate. What's the difference? There's no difference. The door is not dispositive. You
Well,
have
if
to
you're
have
running a dental office, there's a big difference.
Well, I mean, of course, Judge, but I mean, you have to have a way of getting in.
So what was your extrinsic evidence showing that he paid for the courtyard?
Well, the extrinsic evidence is the unrebutted testimony of both Dr. Koritz and his transactional attorney that the co-op never put anything in. If you take a look at the record, all they have is an attorney affirmation introducing certain exhibits. There's no rebuttal, Judge. That's the point. That's what's so silly about this case. There is no rebuttal here as to what Koritz said, and it's backed up by 42 years of it was
Keeps going up. It was
it's from
35,
82
then
to
it was over
217.
40, now it's 42.
It was from 82 to 2000.
At some point, it's going to be 100 years, you know?
Well,
Isn't it 35?
It was 35. It was 35. I let you go to 40, but you can't go to 40.
Okay, you got it.
You have time on
Thank you.
rebuttal.
Thank you.
Good afternoon, Your Honors. Michael Weiss of Cullen and Dyckman for the response.
So was there anything to rebut the contention that the courtyard was part of the negotiated space?
Yes, there was, Your Honor. I mean, the primary rebuttal was the extrinsic evidence adduced during discovery, and it was actually the evidence, that extrinsic evidence that Dr. Koretz relied upon principally in the court below, which he's now impugning, which was the appraisal report for the issuance of shares, the inspection report in connection
But
with.
why should you be allowed to push aside this 35-year practice, which is some indication of what was intended, is it not?
Well, I mean, course of conduct can certainly be a factor, but it can't be the sole factor. And here you have a situation where he's claiming exclusive use for.
So what does the appraisal report say, which you say supports your position?
What does it say, Your Honor? The appraisal report, it says a few things. First of all, it ties the share allocation to a private entrance. It references the fact that maintenance fees are generally higher for a professional office as compared to a residential unit. It ties a great deal of the value to the fact that it's approved for commercial use. It was the only unit in a 215 unit otherwise residential building that had a commercial use exception.
So it says nothing about the extended space.
It says nothing about that, Your Honor.
That's from November 1988.
Correct. And every piece of extrinsic evidence in this case that was contemporaneous to the drafting of the agreement works in the cooperative's favor. It shows that there was no intent to give Dr. Koretz this expansive right, this right to this outdoor area, this courtyard in prime real estate in Manhattan, which presumably if the parties had intended to give that to him, it would have been mentioned explicitly in the contract. These were sophisticated parties working at arm's length, both represented by attorneys. Counsel for the appellant referenced the attorney draftsman on behalf of Dr. Koretz, who did submit an affidavit in the court below. And it's interesting that nowhere in that affidavit does he state that here this was the intent of the parties to give Dr. Koretz this outdoor area. He just parrots language that's stated in the supplement that this court previously found to be sufficiently ambiguous to allow extrinsic evidence in.
If this was a private entrance, and it is for all these years and in writing, what was the purpose of the ramp? What was the purpose? I mean, your friend argued that the ramp was not necessary, putting aside whether it should have been positioned in a different part of the building, where there are experts on this record claiming that it could affect the integrity of the building, so to speak. If it's a private entrance for the doctor and his patients, why did you need a ramp there?
Well, Your Honor, so the ramp is, first of all, it's an ADA ramp. It's a building that was constructed, prior to ADA rules coming into practice, and the building didn't have handicap access. So it was something that was built for the residents to provide handicap.
How could it be built for the residents if it's a private entrance to the doctor? In other words, did this ramp lead to other parts of the building? I mean, I just saw photographs in the record. So this ramp would lead to the lobby.
The main lobby entrance that's
Never
utilized by all
mind,
of
you've
the
answered the
upgrades.
question. I'm sorry, I couldn't tell from the photographs.
Well, Your Honor, I mean, if there are no further questions, I mean, I'm comfortable resting on the papers.
Thank you.
Thank you.
I'd like to point something else out, Your Honor. Their counsel, the only statement that we have from them, other than reliance on these three documents that all precede the sale, is this letter that the co-op's attorney sent to our attorney. And it said that, this space here, whatever you want to call it, this space is actually a terrace. It's a terrace, and that's why there were more shares allocated to it. And if you take a look at the language, you get the more shares because of exclusive use. And that triggers paragraph 7 of the proprietary
So you're
lease.
saying that at some place in the proprietary lease, it refers to the outdoor, it refers to it as a terrace?
It's their contention that that space was actually the roof of the basement, and it's a terrace. It's in there. I can cite to you that page.
So is there something in the proprietary lease that says that you pay additional monies, or that Dr. Koretz paid additional monies for the terrace?
No, it doesn't say in the proprietary lease, but it's covered by the supplement, which says that the lessor shall not prevent such use, which is our use, except in case of emergency or to comply with legal requirements.
Was this brought up in the original case before us, that this was somehow In the supplement, it was a terrace, and therefore Dr. Koretz had exclusive use to it?
I don't know if it was in the underlying papers.
I don't believe that it was.
I don't think it was the first time it became
Yeah.
before you, but it was certainly came before Judge Cohen.
So what was the context of that lawyer's letter?
Well, the lawyer's letter had two things. One, it was apologizing for the interminably long local law 11 work that affected him and the rest of the people in the building. And the other part of it was a polemic to tell him, don't make a fuss over this. That don't sue us for having usurped your space. Now, again, Judge, look, you can say it was a handicap ramp. I don't care what you want to label it as. They took 30% of the space that we bargained for, that we paid additional money for. We are entitled to be compensated for that. The first cause of action, that's what it seeks. It seeks a reduction. The fourth cause of action asks you to tell them to buy back the shares and just restore us to the status quo. If you're going to usurp our space, make us whole for what you've usurped. Thank you, Your Honors.
Thank you. Thank you both. People v. Jose Perez.
Good afternoon, Your Honors. Isabel Patkovsky on behalf of the Legal Society for Jose Perez. Because the court gave no reason for imposing an order of protection against Mr. Perez.
Was there a this was a final order of protection following the defendant's plea to robbery in the third degree, and this is at sentencing where a final order of protection was issued. Is that correct?
Correct, Your Honor.
Was there a temporary order of protection that was issued at arraignments or at some prior point in the proceedings? So the defendant was well aware, or was aware that there had been, or there was an order of protection in effect, right?
Yes, Your Honor.
Okay. So the rationale for alerting a defendant to an order of protection at the time of sentencing and placing that on the record is to give the defendant notice. Is that correct?
I don't think that the law explicitly states what the rationale for it is. I think that courts have recognized that because orders of protection are so consequential, final orders of protection place very long limitations on defendants.
You didn't raise this issue below. Isn't it therefore not preserved, to say nothing of the fact that there's a waiver of the right to appeal here?
We agree that it's not preserved, Your Honor. We're asking this court to vacate the order of protection in the interest of justice. And we don't believe that a waiver of appeal prevents this court from reaching this claim.
Why not?
In fact, this court has reached this claim in the past.
But what is the interest of justice, to take your first one, what is the interest of justice consideration here for us to consider this when it's not preserved? After all, had you raised the issue below, the matter would have been quickly resolved.
I think
and the circumstances of the case show why an order of protection was in fact issued.
Respectfully, Your Honor, I don't think the circumstances do show that. Crucially, our courts do not impose orders of protection automatically in any criminal case, including assaults.
But wasn't this a part of the offer that the prosecutor made? That was part of the offer.
Yes,
that
Your
there was going
Honor.
to be a final order of protection.
Yes, Your
And
Honor.
there had already been a temporary order of protection.
See, that kind of went to my question in terms of notice to the defendant, because I'm assuming you're claiming some type of prejudice to the defendant as to being unaware of an order of protection or the reason for the order of protection.
Yes, the second of that, Your Honor.
Okay, so again, there's a temporary order of protection. The plea agreement or the offer by the people is to plead guilty to the Rob 3 with probation, I think, and a full order of protection. Oh, excuse me, 2 to 4 with a full order of protection. So again, aside from the fact that it's not preserved, where is the prejudice to the defendant?
Well, I think the prejudice comes from CPL 530.13, which specifically says that a court has to give a reason for issuing a final order of protection. It's not considered something that can just be done without explaining why.
But the case law states that if, in fact, there is notice to the defendant, the circumstances, the consequences, et cetera, then it's fine. Then it's allowable.
In People v. Calderon, this court vacated an order of protection because the court had not given any.
Yeah, I think I was on that case.
Yes.
But I think that, and if I'm not mistaken, I was a part of the panel on that matter. And I believe the people actually consented to vacating the order of protection.
They did consent, but this court independently found that the order of protection was invalid and then said, as the prosecution has consented. This court did not say that it was vacating the order because the prosecution had consented.
It's my understanding, you don't challenge the plea itself, correct?
No, Your Honor.
So am I wrong that with a valid guilty plea, there can't be appellate review of non-jurisdictional defects such as this case? Isn't a challenge to the FOP forfeited by virtue of what you now concede as a valid guilty plea?
I don't think so, Your Honor, for the simple reason that this court has numerous times weighed in on questions regarding orders of protection, and Neves explicitly says that an order of protection is appealable after a conviction. Granted, I think the law is a little bit unsettled, but certainly this department has never considered an order of protection, a challenge to an order of protection waived by the guilty plea itself.
So could we remand for the judge to state on the record the reasons for the final order of protection?
I believe you could remand, Your Honor, but because this is really a legal question, we don't think that that's the right remedy. This court—
But that is a remedy, right? We could simply remand, vacate the final order of protection, remand, and then the judge could state on the record why, given the circumstances of the robbery in the third degree and the assault, there would be a final order of protection, right?
I think it's the wrong remedy because the court failed in its statutory obligation.
So the correct remedy would be to vacate the order of protection and therefore not have any protection whatever to the victims in this case?
Yes, that's correct, which I think is supported by the record, given that there was no pre-existing relationship between Mr. Perez and the complainant, no evidence that he ever tried to contact the complainant, and no expressed desire from the complainant for a protection.
And no objection by the defense to either the temporary order of protection or the final order of protection, which was stated at the end of the sentence, right?
Correct, it is unpreserved.
Thank you.
Thank you.
Good afternoon, Your Honors. Jonathan Sklar for the Office of Darcel D. Clark. May it please the court. Your Honor, defendant's failure to preserve this claim explicitly excludes the victim from the process. The proper method for defense is to go before the sentencing court and ask the sentencing court to vacate the order of protection or state the reason so that we can consult the victim whom was beaten by defendant and others with a pan, with their fist. They stomped on him, then they robbed him. In a living room, they were all together in a living room. This idea that the victim didn't know each other is kind of absurd and isn't borne out by the record. So the proper thing for the defense to do is go before the sentencing court. As Your Honors point out, People v. Calderon is kind of like a red herring precedent because it was a Bronx case. We consented to it. The victim there was a superintendent of a vacant apartment in which the defendant had burgled, so there had been no contact and no way defendant could have contacted the superintendent.
When you say go before the sentencing court, you mean at the time of sentencing, to do it at that time?
Sure, at the time of sentencing.
Or after.
Or after.
There could have been a motion. There could have been a motion made after to vacate the order of protection, as opposed to coming as opposed to appealing to this court.
Exactly, Your Honor, and that's what the preservation rule from People v. Nieves is for, so that.
So that was my question was, again, if we found that there should have been some statement on the record by the sentencing judge as to the final order of protection, as opposed to just final order of protection is issued, as was stated, that we could remand back to the sentencing court for the judge to state on the record the basis for the final order of protection.
Correct, Your Honor, and that's the proper remedy, given that vacating it without remanding would actually result in an equal violation of the statute, which says the court must state its reasons for issuance or non-issuance of the order of protection. We ask that you affirm. Thank you.
Thank you.
Very briefly, Your Honors, the victim was never consulted in this case to begin with. The pre-sentencing.
How do we know that?
Because the pre-sentencing report says we did not speak to the complainant. So there's no indication whatsoever on this record.
Does that foreclose now attempting to speak to the victims to determine whether or not they wish the order of protection to remain in effect or not to have an order of protection?
I think it does foreclose that, Your Honor, and this court and other courts have reached unpreserved challenges to orders of protection where the reason wasn't given and where nothing on the record supported issuance of that final order to begin with.
So again, I understand that you wish us to vacate the order of protection. There would not be an order of protection in effect. What is your position in terms of remanding for purposes of the court stating on the record the basis for the issuance of the order of protection in either issuing an order of protection or not?
I would need to ask my client who's currently incarcerated. I'm not quite sure how that would work.
Well, it would work being brought back down to the Bronx to be before the court, so that the court could state final order of protection issued for the following reasons. But thank you both. State Farm v. Equinox Physical Therapy. Yes, counsel.
Good afternoon, Your Honors. May it please the court, my name is Stuart Bodoff of Rifkin Radler, appellate counsel for plaintiff respondent State Farm. In this case, Your Honors, the Supreme Court correctly granted State Farm's motion for summary judgment as the claimants for no-fault benefits, the defendants assignors, each failed to appear for 2 scheduled examinations under oath. The claimant's failure to appear was then imputed to each medical provider assignee and allowed State Farm to deny all claims retroactively to the date of the loss. Your Honors, whether or not the timing regulations were applicable, whether this was a pre-claim or a post-claim EUO letter, EUO request, the letters were done timely pursuant to the regulations. State Farm also provided its good faith or objective basis for seeking the claimant's EUOs through the affidavit of its claims specialist, Lori Madigan. There was possible misrepresentation in procuring the policy where the insured's address, where the car was garaged, Rochester versus Brooklyn. It was possibly not an accident based on police reports, the lack of injuries at the scene, and then getting no-fault benefit applications from each of the passengers in the car. Summary judgment was not premature because Ms. Madigan provided the affidavit. Medical providers made no reasonable request for any further discovery. And finally, State Farm was not required under this court's precedent in Unitrin and the cases for many years after Unitrin. They did not need to timely deny the claims, although there is evidence in this record that they did so within 30 days. If the court has no questions, I would rest on my.
No, thank you so much.
Thank you, Your Honors.
Landa v. Friedman.
Good afternoon, Your Honors, and may it please the court. Jason Zakai of Hiller PC for the appellant, Mark Landa. Your Honors, the respondent's third-party action is barred by collateral estoppel, and the decision below should be reversed. The third-party complaint against appellant and respondent's ex-wife, Elizabeth Friedman, concerns respondent's purported ownership interest in an apartment to which he never had title and which he admits in his own pleading was marital property during his now dissolved marriage to Elizabeth.
So this was litigated in the divorce action?
Yes, Your Honor. It was fully litigated. The respondent admits that it was marital property, and under the DRL, the Domestic Relations Law, Section 236B5A, in an action of divorce, the court shall determine the respective rights of the parties in their separate or marital property. Thus, respondent's rights in marital property, such as the apartment, must have been determined by Justice Hoffman in the matrimonial part when the divorce proceeding was litigated. And again, there's no dispute. He says it in his pleading. The property was acquired by Ms. Friedman during the marriage before the divorce commenced. and regardless of the form in which title is held. So regardless of the fact of who else is on title, including the appellant. So the only chance that respondent had.
Was there any mention of this apartment in the judgment of divorce or in the stipulation that was placed on the record on October 21st, 21?
No, the judgment of divorce just said all marital property has now been dissolved and all marital property has been equitably distributed. All ancillary financial issues have been resolved by the parties. In fact, there was a...
Does the record reflect who has the apartment now?
Well, because there was no conveyance, so it stayed with the titled spouse, which was Elizabeth.
Elizabeth. Alexander has a third-party action against Elizabeth for this claim of Mark Landa against him, right?
Yes, in the same third-party action, the respondent's bringing the claims against both Mark and his ex-wife. So he's just relitigating the divorce in this third-party action all over again.
This is really only about the notes.
Well, the respondent may be looking to get maybe make a defense about the notes, but his third-party action is, I want a declaratory judgment in the...
But if you prevail against Alexander on the notes, Alexander's going to turn to Elizabeth to help pay them.
He might.
I mean, that's the point of his third-party action.
Well, yeah, that's the claim against Elizabeth. That's the third cause of action in the third-party complaint. What's before the court today is the first two causes of action, which are against his ex-wife and Mark about constructive trust, declaratory judgment on the apartment, which was no doubt, no dispute, marital property.
But he's claiming that collateral estoppel is inapplicable because he was not a party to the divorce litigation.
Well, respondent is completely wrong as a matter of law because collateral estoppel doesn't require mutuality. So appellant who is not a party to the divorce can assert a collateral estoppel as an affirmative defense, and to say respondent was a party in his own divorce proceeding, he can't really relitigate identical issues all over again. The respondent had his day in court, and that's it. And all these issues of marital property were disposed and distributed. As far as there's an argument about draft settlement agreement, those were no negotiations that occurred. Obviously, that is not evidence. Those are only negotiations. There was no written agreement that came to pass. What happened was the oral stipulation on the record, and then we had the divorce judgment entered by Justice Hoffman and said that all marital property is distributed and resolved. Briefly, in addition, there's an argument about documentary evidence, and also that another ground for dismissal is failure to state a claim for constructive trust and should have been dismissed under 3211A7. Respondent fails to plead any of the elements of constructive trust. Courts routinely dismiss actions including constructive trust where elements are not pleaded. Those cases started into our brief. There's no allegation of a confidentiality relationship. There's no allegation of a promise made by the appellant or a transfer in a reliance on the promise. There's no mention of one word of reliance in his entire pleading, nor there is a mention of unjust enrichment. Now, respondent's going to rely heavily upon the second department case of Capra v. Stalinsky, and there's two important distinguishing factors there. One is that in that case, the plaintiff actually made an allegation of a promise. That didn't happen here. And two, that case, that spouse made that claim against her father-in-law while the divorce was still pending. And if respondent thought he had a claim against his father-in-law, the appellant, his time to do that was, again, goes back to collateral estoppel argument. His time to do that was during the divorce proceeding. He failed to do it. He waived his interest. If he thought that he should be some offset or distributive award relating to the apartment, he could have made that claim. He could have impleaded appellant, but he failed to do it. The divorce went to judgment, and it's over. If the court has no further questions, I'll save any time for rebuttal.
Thank you.
Good afternoon, Your Honors. Kyle Kuntz for Respondent, Alexander Friedman. I I'd like to begin by asking the question of what exactly are the interests that were decided in the underlying divorce action. And the interest decided in the underlying divorce action was marital property. This third-party complaint is not about marital property. This third-party complaint is about Mark Landa's ownership interest in the apartment. He's not a party to it. He was never a party to the divorce. He didn't obtain any ownership interest
Wasn't
in
the apartment the marital home?
Well, there's dispute about that, Your Honor.
Isn't that where they lived? Isn't that where they had their addresses?
That's where they lived. However, Your Honor, the underlying testimony by Mr. Landa is that not only was the apartment never meant for Alexander, the down payment was never meant for Alexander. His name was never placed
It was
on
acquired during the marriage.
It was acquired during the marriage, but it was intended only to be Elizabeth's asset.
Isn't property acquired during the marriage considered to be marital property?
That is the presumption, but that's a rebuttable presumption. And there's allegations within the third-party complaint that the testimony and the evidence given by Mr. Landa and Ms. Friedman was that this was never Alexander's apartment, Your Honor.
So I sat on Landa 1, Justice Mendez and Justice Friedman sat on that as well. My recollection was there was a reason why it wasn't put in his name was because he was going to be starting some other venture. Perhaps he had poor credit or something of that nature. And that's why it wasn't put in his name, it was put in his now ex-wife's name. But again, it was property that was acquired during the marriage. They lived there, that was their marital residence. And he stated in the affidavits that that was marital property. So I'm not understanding. Now he's stating something different?
So, no, Your Honor. So your recollection of what he said previously is spot on, yes. That was our argument as far as why his name was taken off the property. Now, Mr. Landa now says, no. That's proof that that apartment was never meant for you. You were not supposed to have that apartment, number one. Number two, there's testimony, and these are the allegations from the third-party complaint that must be taken as true. There's testimony provided by both Ms. Friedman and Mr. Landa in the underlying divorce action that the apartment was never meant for him. The funds obtained to purchase the apartment was never meant for him. They purchased these. Mr. Landa borrowed the down payment from his parents' trusts, over which he's a trustee, about $560,000 between the two of them. Mr. Landa's testimony is that as between himself and his parents, those funds were never meant for him, for Mr. Friedman. So now we have this issue where the notes used to secure the debt on the apartment are being held against Mr. Friedman only. There's two sets of notes, one set signed by him and his wife, one signed set by Mr. Landa and his wife. Only Mr. Friedman is being held liable for the debt on this apartment, and that's it.
But he's not being held liable for the ones that Mr. Landa and his wife signed. Only the ones that Mr. Friedman and his then wife signed.
That's correct, Your Honor.
And for that, he's bringing an action against his ex-wife for contribution.
That's correct, Your Honor. As far as Mr. Landa is concerned, he has testified that he is also an owner of this apartment. He has a separate ownership interest. Clearly, his ownership interest in that apartment is not marital property.
Was there a carve-out, whether in the stipulation or in the judgment of divorce, regarding this apartment?
No.
Was there was it somehow accepted?
It was, Your Honor, and that's the argument we made to the trial court. It's within our brief, and that was the subject of a separate motion. We incorporated that entire motion into this motion, and it was accepted. The trial court accepted that this issue of the notes, the issue of the apartment, the issue of potential future litigation was carved out as between the parties, creating an exception to res judicata.
The battle over the notes is a proxy for the battle over the apartment, and that was determined in the matrimonial action.
I'm sorry, could you repeat that, Your Honor?
The battle over the notes is a proxy for a battle over the apartment, and that issue was resolved in the matrimonial action.
So then that begs the question, if the notes is a proxy for the apartment, which is already decided, why are we here defending Mr. Friedman from paying the debt on the apartment?
Because you're suing him, you want a declaratory judgment that Mr. Friedman is somehow still entitled to the apartment. But that, according to Mr. Landa, was already resolved in the divorce action.
The ownership interest, and again, we argue there's a carve-out. That argument is within our brief. So assuming that's true for the sake of argument, the issue with respect
The carve-out of what?
the carve-out of the divorce action, the divorce judgment, there's a carve-out with respect to the notes and the ownership of the apartment. That's the argument. But for the sake...
Anywhere in writing?
Sorry, go ahead.
Yeah, is that in writing?
Yes, and there's back and forth between the parties. There's a tremendous amount of back and forth. That was attached to the other brief, which we've incorporated by reference. I see my time is up. Would you like me to...
What are the terms of the carve-out?
I'm sorry, Your Honor?
What does the carve-out say about the apartment?
Well, it was within the parties' settlement agreements, whereas our side provided a settlement.
Well, does it say that the apartment issue hasn't been resolved?
I mean, it as between the parties, yes. Throughout the emails back and forth between prior divorce counsel, there's express statements saying, "You've taken this out of our settlement agreement. This leaves him open for potential future litigation, but it also leaves open the potential issue of his ownership interests in the apartment."
So is that a part of this record?
No, that's not a part of this record, but the issue was that...
So if it's not a part of this record, then we can't consider that?
Well, you can't consider that, but here's the thing, Your Honor. That argument was accepted by the trial court. We incorporated by reference that entire brief within the underlying brief. It was not attached to this record. So this argument...
And you also did not argue that on appeal here?
I'm sorry, previously?
Now, in this record, that there was a carve-out?
No, it's in our brief. It's in our brief that we argue that there's an exception applies to res judicata because the parties carved it out for future litigation.
Thank you.
Briefly, Your Honors.
What do you say about the carve-out?
I'm sorry?
What do you say about the carve-out?
Respondents' counsel is talking about settlement negotiations, which I addressed earlier, which are not part of the divorce judgment. There was some negotiations. So what happened was there was an oral settlement allocution on the record, and they decided what the distribution was. It was an agreed amount of money and issues dealing with the child support and things of that nature. That's it. And the Judge Justice Hoffman said, parties, do you agree on the record to be bound, even if there's no written agreement after this? Respondent said, I do. I believe it's page 204 of the record. And then...
Right, it says you have resolved all economic issues of equitable distribution of marital property.
Right.
And then the answer was yes.
Right. And what Respondent's counsel is referring to is afterwards, the lawyers got together and said, hey, can we work out anything else? They had back and forth. If they left out things for potential litigation, that was on divorce counsel. That was a problem because they missed the law on the DRL that says once this divorce is over.
So as we stated earlier, ownership interest is gone.
It's gone.
What the fight here is the notes, whether Mr. Friedman is liable under the notes, and if he is, then he has, as been pointed out, a claim against his ex-wife for contribution. That's what this is all about.
Yeah, and the notes are not before this court today.
No, I understand.
You know, it's the third party action. So what's before is hey, you know, there's an affirmative defense to the third party action. If you want to litigate the notes separately, we can do that. But this is just wrong as a matter of law. The judgment of divorce says what it says. It says all issues and by the way, in addition to all issues of equitable distribution, it says, as said in the oral stipulation, going back, incorporates that settlement allocution with which respondents said on the record. See, my time is up. Thank you, Your Honors.
Thank you. People v. Angel Ramos. Kill me. This one makes such noise. It's like chocolate. Oh my God. It's driving me crazy.
I don't know what's wrong.
Well, stop. Stop. Your child. Stop. Stop. Yes, you may proceed.
Good afternoon, Nyla Siddiqui for Appellant Angel Ramos. The trial court erred in summarily denying Mr. Ramos's request for a hearing to determine whether the drugs recovered were lawfully obtained. Mr. Ramos not only specifically denied participating in the drug transaction as described by the police, which is required under Mendoza and Jones.
Yes, so don't you need sworn allegations of fact?
That is a sworn allegation of fact that he
What
was
was
not
the sworn allegation of fact that he was, I'm looking at the, at his motion, at your motion. It's just that he was innocent, was engaged in innocent conduct when approached by the police and did not participate in any drug sale.
And this court has held explicitly in Lopez, where defendant explicitly denied selling or possessing drugs. In Mohammed, defendant denied.
A generalized denial of criminal conduct does not typically set up a factual dispute calling for a map Dunaway.
That is correct.
The defendant had more information about what had occurred and was in a position to make more specific factual affirmance, which could have necessitated a suppression hearing.
So the courts have held that the factual issue that someone was not a participant in the drug transaction, this court has held in Rivera, Mohammed, Lopez, Marquez, Bennett, and many more cases. And in terms of a non-specific, in Mendoza, quote, acting in a lawful manner was a non-specific thing that did not controvert a factual allegation. Similarly, in Jones, not engaged in any criminal conduct. In Garay, not committing a crime. In Bennett, this court denied a hearing when someone asserted their innocence and denied wrongdoing. In Heath, illegal
There's
criminal...
an allegation here, for instance, that the undercover gave your client $30, which the defendant then gave to White in exchange for PCP packages. So what did he say about that? And that there's also that a PCP bag was recovered from his person upon arrest.
Well, so first, that is, more is not required. This court in Rivera says that the additional requirement urged by the people that defendants specifically deny in detail exchanging a small object for money is a standard not required by either statute or case law. In Lopez, this court held a higher level of specificity is not required. Again, denying selling or possessing drugs was sufficient.
But in Way, as well as in Cartwright, we stated that a defendant must refute the specific information provided by the people concerning the basis for the defendant's arrest.
Yes. And
so again, denying participation is, here, the defendant had ample information based upon the complaint as to deny, as my colleague stated, that he spoke to the undercover or he spoke to an individual, that he steered or directed the undercover to White, that he was in possession of U.S. currency, that he was in possession of PCP. I mean, there were so many things that he gave the 2 bags of PCP to the undercover. There were so many things that the defendant could have denied, and all he said was that he wasn't engaged in any criminal conduct.
That's not what he said. What you just described is a drug transaction. He was a participant in the drug transaction, and
denied that he participated in any drug sale.
Transaction. And so whether or not he was a participant in the drug transaction is a factual dispute. He did not simply say that he was innocent of any criminal conduct. The drug transaction is what they're accusing him of, being a participant in selling drugs. And so that level of factual specificity is not, as this court has held, is not required. Denying participation in the drug transaction is what Mendoza simply requires. Again, this court in Huggins, it says defense counsel's affirmation could have been more detailed. Defendant's motion papers contain sufficient facts. Here, denying the participation in the drugs transaction is a fact. And in Heath and Way, in those cases, they don't even mention a drug transaction.
Right. So I just want to be clear. This occurred in 2019. The defendant was convicted in 2019. He was sentenced to 3 years probation.
Well, first he was participating in I think, drug treatment programming and cases that went on for a couple of.
But my point is, this case is over. He completed his 3 years probation. Is that correct?
Yes, and we're asking this to go back. He did successfully complete his.
So he completed his probation. It's finished. You want the case to be remanded for purposes of a suppression hearing.
Yes, to determine whether or not there was a lawful stop, because it would raise potential defenses that he could have put forward had the judge granted a MAP hearing. This is a drug transaction. If the contents recovered were suppressed, there may not be a case. There may not be a conviction. So in cases where the proof is what we're seeking to suppress, it is, despite him having completed his sentence.
At the very least, wouldn't you have the possession? Or you're saying everything would fall?
Well, arguably,
because I'm thinking even if you're saying that in terms of the sale, in terms of the facilitation of steering the undercover to white, etc., you still have the PCP found on the defendant's person.
That's what we're seeking to suppress. And also, if
you're seeking to suppress the PCP,
that was what was recovered on his person.
Right.
And also, if its facilitation is a misdemeanor, he was convicted of a felony. So facilitation is a misdemeanor, and if this went back and he was only convicted of a facilitation
or the sale, he could be convicted of the sale.
Yes, and he has other defenses available to him, like agency, which would make him innocent of the sale, because he was not the person who retained the pre-recorded buy money or had the large quantity. He only had according to the facts, he only had a small amount of PCP recovered. So yes, it is in his interest to potentially go back for a hearing because he was convicted of a sale.
Thank you.
Good afternoon, Your Honors. May it please the court. Jennifer Cavallas for the people.
So why were sworn allegations insufficient?
So here, a defendant made cursory, conclusory allegations. I was just walking on the street, and he denied participation in the drug sale. To the contrary, the people alleged significant allegations, including the date, the time, the location, the undercover officer's name, UC-76, the people that he was involved with, the co-defendants, the type of drugs, the amount of drugs, the amount of allegations that the people set forth here allow the defendant to contest something. It's not the people's contention that defendant needed to address every single one of the people's facts, just some of them, and just denial of participation in a drug sale, this court has held is not enough under these circumstances. The cases that defense points to, specifically Rivera and Marquez, and cases of that progeny, in those cases, the defendant raised far more specific allegations, and the people's allegations were scarce. Here, the allegations are numerous by the people, and defendant simply doesn't address anything that the people allege. Not even addressing why he was at that location. There was a specific address noted here in the felony complaint, in the indictment, and at the plea, defendant allocated to that as well. So all of this defendant had access to, and he just did not address. And also the people's allegations fully and clearly set out probable cause for the arrest. So there was absolutely no basis.
Well, he said he was walking on the street when he was stopped, and that he had committed no act which justified the police intrusion and had not participated in the sale of drugs.
Yes, and that's simply not enough. There's no factual dispute there being raised, especially when the people have made specific allegations about all the details of this arrest, including the people that were present. The defendant didn't address any of that. They raises absolutely no factual dispute that would warrant a hearing. And on top of that, the people's allegations in the motions fully support the probable cause of the arrest. So there's absolutely no reason to hold a MAP hearing for this when probable cause was clear on its face from the papers. It would be a waste of judicial resources. That's the purpose of Mendoza, and the judge used Mendoza properly here. If there's no further questions, we ask that you affirm.
Thank you.
Very quickly, the prosecution's incorrect that Mendoza specifically says in buy and bust operations, denying participation in narcotics transaction or some other issue for suppression is all that is required. That is a case that defense attorneys have been relying on. This court has upheld for so long. And in Mendoza, the court rejected that, quote, acting in a lawful manner was not tantamount to a denial of drug dealing. So here, they denied participation in a drug sale, and that is all that is required. The issue, could there have been more pled? Yes, but it is simply not required, and there was not. And the issue for the hearing is to determine whether or not there was probable cause for the arrest that could have led to suppression in the drugs that were recovered. Okay, and so it is not conclusory. Not participating in the drug transaction is a fact.
But Mendoza also states that courts should consider the face of the pleadings, the context of the motion, and the defendant's access to information. That's what my colleague and I were questioning in terms of the fact that this complaint had so much information in terms of UC 76, steering, the PCP, et cetera. So under Mendoza, there still is a requirement that the defendant give some factual allegations in the context of the information that was given, access to the information in the complaint.
No, Mendoza only requires denying specifically the conduct that is alleged.
In deciding whether the factual allegations merit a hearing, courts must consider the face of the pleadings, the context of the motion, and the defendant's access to information. That's what Mendoza says.
And here, what the information that was provided was that he was a participant in a drug sale, and defendant was specifically denying participation in a drug sale.
Thank you. Thank you both. Bapaz NYC versus ASA Properties.
Good afternoon. May it please the court. My name is Robert Kaplan. I represent the defendant appellants in this case. As your honors know from our papers, we contend that there are a bucket full of reasons why the judgment and order below should be reversed. The motion court admitted that it based its decision to grant summary judgment to the respondent on its first two causes of action upon the contents of an alleged settlement agreement which respondent came forward with for the first time at oral argument. It was error as a matter of law for the motion court to have considered that document. This court has consistently and repeatedly held that a court should not consider new evidence which a party seeking summary judgment tries to include in its reply submissions. These rulings are grounded upon the recognition that such a movant is required to show its entitlement to summary judgment in its moving papers, and if it does not do so, its motion will be denied regardless of the sufficiency of the opposition or anything else that's submitted.
Speaking about moving papers, wasn't there a set of emails that was attached to the cross-motion papers as exhibit, I believe, CC, that in essence dealt with settlement negotiations that were taking place with a gentleman by the name of Lavi, one of the defendants here, that actually led to the settlement agreement?
Yes, Your Honor, there were such emails. I want to refer you to this case recently decided by this court called Benedetto versus Hyatt Corp. We discussed this case in our papers. Merely making suggestions about evidence in your moving papers doesn't allow you to come back in your reply papers with more evidence. In that case, someone made a motion, the third party complaint involved a dispute over whether someone had breached a contract to procure insurance. The third party defendant moved to dismiss that complaint. In its moving papers, it relied upon the certificate of insurance and relied on the declarations. Then in its reply papers, it wanted to submit the actual text of the policies, and the motion court said, no, you can't do that, and this court affirmed that.
Right, but here the motion court found that this was an exceptional circumstance or a special circumstance given the fact that the Lavi settlement contradicted statements made in the proceedings about Lavi. And therefore, there was some type of, fraud on the court being perpetrated because this information had not been made known to the court and
Your
was
Honor-
not included in the papers. And it was also an issue as to why that information as to the lobby settlement was not included.
First of all, Your Honor, the court didn't say why it was permitting it. Second of all, the court didn't cite any reason, any authority for that.
Well, the court noted, they noted that the lobby settlement contradicted the statements made in the proceedings about lobby.
But Your Honor, everyone wants to if anyone after motions are submitted would love to have the opportunity to come up with additional evidence to contradict.
Is this just a matter of additional evidence, or is this something which totally undermines the position which you had set forth to the court before?
Your Honor, there's no case law that says you can't come back with evidence, with new evidence in a reply or after a reply. But if it's really good evidence, maybe you can. Furthermore, there was evidence in the record.
Which is indicative of a fraud on the court?
Wait,
What
please.
if it's evidence which is indicative of a fraud on the court?
It's not a fraud on the court. There was evidence in the record that prior to the plaintiff's purchase of this limited liability interest, it was told all of the facts concerning Mr. Lavi. And that testimony has never been controverted. They told him, yes, Lavi wanted to purchase an interest, but he didn't pay. He was supposed to pay X. He didn't pay all of X. The documentation wasn't done. Then Lavi said, well, I'd like my money back. So that was all disclosed to Lavi, to the plaintiff, and no one has disputed that. Furthermore,
Wait, counsel, there's a question.
Oh, I'm sorry, I don't mean to cut you off, but isn't the heart of your appeal the error in granting the $700,000 award, the second payment, they didn't prove it? Isn't that an issue here?
Yes, that is an issue, Your Honor.
So in other words, you challenge the initial granting of summary judgment for the full $2 million.
Well, obviously, we challenge it for the whole thing because
No, I understand, but again, the core issue that you're raising is unlike the paper trail that justified the first payment of the first $1 million from the Hershkovitz account and under the PSA, it is your contention that there was no money paid under the remaining agreement.
it's not there was no money paid. There was no second agreement. No one has claimed that there was a second agreement. I would refer you to the testimony of plaintiff's principal Israeli. He admitted in his deposition he could not say if the respondent was ever bound by any second agreement. He said he could not recall ever seeing any second agreement. He admitted never recalled discussing any second agreement. And he didn't know whether the option to make that second purchase was ever exercised. How can you award, if you have a breach of contract, you have to have a contract that was breached. There was no contract, so it couldn't have been breached.
You have time on rebuttal.
Excuse me, Your Honor?
You have time on rebuttal.
Okay, thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the court, Claude Castro for the respondent. Addressing the issue of the settlement agreement, I submitted a reply affirmation at 1197 where I stated to the court, quote, I would ask that this court direct the defendants to produce at oral argument a copy of the confidential settlement agreement that was entered into in the lobby litigation. I did that because that agreement was under confidentiality order. I had it. I asked counsel to produce it. And I told the court in this same affidavit what Your Honor said. All the terms of this settlement agreement were in emails that were produced by the defendant's counsel. They knew about it. And what happened is, Your Honor, at the oral argument, the judge asked his predecessor counsel, Mr. Fetter, was there a settlement agreement? He says, it doesn't make sense to me that this kind of case would be settled without a settlement agreement. And Mr. Fetter, and there's no other way to say it, lied. He said to him, no, Your Honor. Mr. Lavi walked away and got zero, at which point I stopped him. I said, Counselor, do not commit fraud on the court. At which point the court looked at me and said, is there an agreement? I said, yes. I didn't go in there and saying, waiving it. I was concerned about the confidentiality. It wasn't until the court at oral argument directed me to turn it over.
And that's why it was not included previously?
That's correct. But I asked them, and I asked the court, direct them to bring it. We asked for them to produce it in discovery. They never did. They were hiding it. And when the judge looked at it, he said, wait a minute. This is not just a settlement agreement. It's an admission. You're admitting Mr. Lavi owns 20%. And the question was, how was he going to get paid for that 20%? So what counsel is telling you really is that they wanted to continue this fraud on the court. And this is exactly what they were, because we have affidavits from Mr. Asa in the Lavi case, in the case before Judge DeGust, where he admitted that Mr. Lavi owned 20%. In fact, he made a motion in that case asking that the court determine his percentage. Mr. August in that case granted, this is the most horrific thing. While we were negotiating, and I was doing it, the purchase of the 51%, they didn't tell us, Your Honor, that Judge August had issued a TRO in April of 2016 restraining them from transferring any portion of the property. So here we are negotiating in 2017 until March. They knew they could, that's why we didn't have an agreement. I was negotiating, asking them, did we have consent from the lender? We were going back and forth. We have emails, Your Honor, going back and forth with Mr. Asa, with his general counsel, without telling us that there was a TRO. It wasn't until March 2017 that finally we're told, wait a minute, Judge August issued a preliminary injunction. At which point, Your Honor, we said, wait a minute, what's going on? That's why we didn't have an agreement. We started negotiating in good faith to try and settle it. And what did they do? They went behind our back, settled the Lavi case, telling the judge, Judge August, that there was nobody else who had an interest. And we had an interest. They signed a stipulation of discontinuance, telling the court nobody else had an interest. We did.
So, counsel, in your time remaining, my colleague had mentioned the $700,000.
Right.
Did you establish that
Yes.
that you paid the $700,000 to the defendant?
Absolutely, Your Honor. First of all, in their answer, they acknowledged getting $700,000. Number two, they produced a document in this record showing payments made by the escrow agent between January of 2017 and 2016, April 2016 and onward. They came up with two stories, Your Honor. During oral argument, they said, oh, this money was for leases that a Mr. Toma signed. And if you look at the leases, and the trial court looked at it, the leases had nothing to do with this transaction. They said monies were paid to the defendants when in fact they were separate landlords. Leases were entered after they collected $700,000. And the judge said to them, how could this money have been paid by an escrow agent for a non-party for leases that have nothing to do with this transaction? Even worse, Your Honor, if you look at, and it's not part of this record, but it is part of the file, number 25, document number 25, Mr. Asa filed an affidavit at that point seeking to dismiss the complaint, and he did two things that are important. He acknowledged the existence of a settlement agreement way back in 2018 when he moved to dismiss, in that affidavit. He also acknowledged receipt of the $700,000, and at that time, it wasn't leases. Now he said, well, Mr. Toma owed me money for shortfall notices. The story kept changing, Your Honor, and the fact, I just want to add two more things. Mr. Asa not only acknowledged Mr. Lavi's interest in this property, he even sent him a shortfall notice in 2017. And the trial court asked him, if he had no interest, why would you send him a shortfall notice? It made no sense, Your Honor. They were just talking out of their mouths. Before Judge August, they were trying to figure out what his percentage is so they could settle. Before our judge, they were denying that he had any interest up until today. And I think, Your Honors, the 700, and by the way, there's also one very important email from the escrow agent, and this is at record 920. He sent them, and he said to them, by the way, we owe an additional $300,000. Because why? The 51% was supposed to be $1 million. This same escrow agent had already sent them $700,000. And then he writes to Sali Asa, the principal, his lawyers, Ben Zuki, his cohort, and he says, I understand there's an agreement in place for Toma to pay down the current debt of $300,000. That's not a number out of thin air. 700 plus 300 is a million. And he says the agreement is to pay this over 10 weeks at $25,000 per week. And then he says to them, if correct, please send me a breakdown of funds received so we are all on the same page. And Richard, in-house counsel, let me know if you or I will write this up.
Thank you.
Thank you very much, Your Honors.
With regard to that last point that plaintiff's counsel made, it's described in our reply briefs at pages 18 and 19. Everything he just said is a bald-faced lie. And he's completely misrepresented the contents of a document and a record. Now, first, plaintiff's counsel said we didn't produce the settlement agreement discovery. There's nothing in the record that says it was ever requested in discovery. Second, the settlement agreement did not acknowledge that Lavi was an owner of the entity. You look at the 10th whereas clause in the settlement agreement, and it identifies the owners of the entity. Lavi is not one of them. There's just a whereas clause that says that Lavi paid some money to buy an interest, which had been disclosed to the plaintiff prior to the execution of the purchase agreement. And what's very telling here is that the plaintiff's counsel stands up and says, what Pete was his papers, oh, it's so horrible what the defendants did, blah, blah, blah. Well, let's look at the evidence of the plaintiff's conduct. The plaintiff admits that at the very latest, it found out about everything on March 30th, 2017. Did the plaintiff at that point say, this has been a terrible fraud, I want my money back, here's your interest back, please give me my money immediately, I don't want anything more to do with you? No. The only evidence in the record is after that date that the plaintiff affirmed its status of an owner of the company by participating in efforts to reach a settlement with Lavi, that it continued to negotiate to buy a larger interest in the company, and in plaintiff's opposing brief on this appeal, it emphasized the fact that after March 30th, 2017, through July of 2017, it continued to negotiate to buy a larger interest in the company. The significance of that, of course, is that the law is settled that if you cannot seek rescission, if you are informed of the facts constituting the breach of warranty, you cannot seek rescission unless you immediately seek rescission.
Thank you. Thank you very much.
Thank you, Your
both.
Honor.
Porter v. Bachner. Yes, you may proceed.
Good afternoon, Your Honors. May it please the court, Patrick Carley with Traub, Lieberman, Strauss, and Shrewsbury on behalf of the defendants' appellants. We are here today because we believe the summary judgment motion was improperly denied by the lower court. The lower court made numerous rulings in its decision, one of which was that there were conflicting accounts between the plaintiff and the defendant as to what was discussed during the course of their representation. Respectfully, we believe that that is incorrect with respect to material issues of fact that go to the reasonableness of the advice provided by the defendant.
Did the plaintiff admit at any time that he instructed the law firm to basically negotiate a deal, an agreement with FINRA, with the FINRA attorney, because he didn't want to be prosecuted. He didn't want to be referred to the district attorney's office.
So the first aspect of that question is plaintiff did admit that he instructed the defendant to negotiate with FINRA on his behalf. Plaintiff neither admitted nor denied that he made that direction in order to avoid potential criminal referral. His testimony on that behalf was equivocal at best.
Well, no, he said that was a major concern of his, and he did not wish to. He was fearful of some type of criminal action being brought against him.
Correct. I may have misspoke. The plaintiff's testimony on that was equivocal.
Right.
The defendant's testimony was unequivocal that that was plaintiff's chief concern, was avoiding at all costs any risk of an arrest.
Even at the expense of a lifetime bar.
Correct. And these are, the record is clear that these are all issues that were discussed with the plaintiff during the course of the representation, that these were...
The plaintiff stated that it was never discussed with him, or he was never made aware as to what that lifetime bar would mean in terms of his future employment opportunities, that he didn't know exactly what he was never told what he could and could not do as a result of that lifetime bar, if he wanted to stay within this, I guess, in terms of finance.
Sure. So plaintiff doesn't dispute that he was told he can no longer be an investment banker. And plaintiff does not dispute, and in fact admits, and it's his testimony, that he had questions about whether he would be able to work for a hedge fund or as an investment advisor, that he asked my client questions to get clarity on that. My client has testified, and plaintiff confirms, that he was told he should speak with another attorney because it's a nuanced area of the law. There's even an email from the plaintiff indicating or asking my client or the defendant who he could contact to discuss that. There's also an email from my client, notwithstanding the fact that he informed him to go find another or to consult with another attorney, but there's an email from my client discussing potential limitations on Regulation D activity in the future as a result of the bar. And the plaintiff specifically responded to that email acknowledging that there were potential limitations and who can he speak with. And he testified that he endeavored to get in touch with another attorney but was unsuccessful in doing so. But nevertheless, despite these concerns that he admits he had, he proceeded to move forward and sign the settlement.
Well, the retainer agreement stated that the representation was one in connection with a FINRA investigation relating to plaintiff's past employment at Goldman Sachs. So would that not also encompass advice as to exactly what this would mean in terms of future employment? Not only that, but coupled with the fact that a lot of this was time sensitive, because my understanding from the record was that defendants were telling plaintiff, you have to make a decision, you have to make a decision. Here's the draft, you have to sign it or not sign it as soon as possible?
Well, I disagree with that characterization. The record reflects that this all occurred over a period of several months. The record also reflects that the question about whether or not plaintiff, the representation itself lasted 2.5, 3 months. The part about my client asking whether or not, or asking the plaintiff what he was going to do, was after the plaintiff was in receipt of the proposed settlement agreement, and the plaintiff or the defendant wanted to know whether or not he was going to sign it. With respect to the question about the scope of the retainer agreement, we've argued that the retainer was more limited to dealing directly with the conflict with FINRA, but even notwithstanding that, the fact remains that my client told the plaintiff that he should consult with another attorney, and in any event told the plaintiff that the FINRA bar would impact his ability to engage in Regulation D activity in the future, which is hedge fund activity, investment advisor activity, private equity activity. All of those types of entities engage in Regulation D, and these are all things that plaintiff having worked in the financial industry and having taken multiple finance-based examinations in order to secure his license, was tested on.
Thank you.
You're welcome.
Good afternoon, Your Honors. Vincent Pizzuto for the respondent. It's the respondent's position that the lower court properly held that there are three main issues of fact that precluded summary judgment in this case. Number one, and the first and foremost, is the
What is it that you would have to prove in order to prevail in this action?
that there is a substantial likelihood, which is what our expert, Mr. Menschel, opined, that if plaintiff was advised to cooperate with FINRA, go down and give testimony and produce documents, that there's a substantial likelihood that he would have been given a less severe penalty than a lifetime bar.
And so your other expert, as well as the defendant's two experts, disagreed.
And the plaintiff's expert disagreed, saying almost the same language. He said there's an overwhelming likelihood that he would have been barred.
Right.
It's a classic dispute between two experts in the field. It's a classic issue of fact. I think it's the first and foremost issue of fact in this case. The lower court also found that there's an issue of fact as to the scope of that retention. It just says, represent him in connection with the FINRA investigation. Our other expert, Mr. Squires, who's defended attorneys in these types of proceedings and has been a member of the grievance committee, opined that, and there's a case that says that you have to prepare and think about every aspect of your client's case. And Mr. Squires opines that Mr. Bachner failed to properly investigate what Mr. Porter was doing at the time, what his future plans were. He was 26 years old.
If someone says that Mr. Porter came to Mr. Bachner and Mr. Porter's concern was to avoid criminal prosecution, and Mr. Bachner accomplished that for him.
Mr. Bachner's testimony was that Mr. Porter's main concern was, I just don't want to get arrested. In Mr. Porter's deposition testimony, that was never asked of him. So I think there's an issue of fact in that regard. But I really think, Your Honor, those are tangential credibility issues of fact, because the lower court also properly said there's so many discrepancies between what Mr. Bachner said the conversations were and what Mr. Porter said the conversations were.
Don't you also have to prove or show that a better deal could have been negotiated?
And we think,
and how would you show that?
we think we did, Your Honor, with the 8 cases. So it's in the record, it's in the briefs. Mr. Bachner produced in his file a memorandum that a former partner wrote in 2012 about prior FINRA decisions and basically adjudications. Mr. Porter came to Mr. Bachner in 2016. In that 4-year period, we were able to find 8 cases where people who were under investigation were given less than a lifetime bar.
Right, but it depends. And the representative from FINRA in this case, I don't remember her name, seemed
Mr. Floyd?
Floyd seemed adamant that there was not going to be any type of, as we would say in the criminal side, plea bargain. That that the only thing that they would accept would be a lifetime bar.
Respectfully, that's incorrect. That's incorrect, Your Honor. Mr. Bachner had notes within his file, and in one of those notes, it talks about one of his conversations with Mr. Floyd. It's in the record. But in the note, it said Mr. Floyd told Mr. Bachner that he would only consider mitigation if...
Very unlikely that Floyd would agree to a settlement that imposed any sanction less than a bar.
But in his notes, in Mr. Bachner's notes, and I questioned him about this, he said that Floyd said he would only consider mitigation, and mitigation would lead to less than a lifetime bar if Mr. Porter came and testified and produced documents.
If Porter instead proceeded with the enforcement action and went to a hearing, FINRA would still impose a bar.
I'm sorry, Your Honor?
It says that more likely than not, that even if Porter instead proceeded with the enforcement action and went to a hearing, FINRA would still impose a bar. That was Mr. Bachner.
That was Mr. Bachner's testimony, but it's refuted, Your Honor, by his own notes where Mr. Floyd told him, I'll consider mitigation if Mr. Porter testifies and produces documents. And Mr. Bachner conceded that 4 of the mitigation factors exist. He had no prior disciplinary issue. Going down would be, and testifying would be substantial assistance. It was a nominal amount of money, about $3,700. And if Mr. Porter readily believed that what he was doing in terms of the receipts was accepted by Goldman, that it would have been negligent instead of intentional. Those are 4 mitigating factors. And by his own notes, Mr. Floyd said to Mr. Bachner, I'm only considering mitigation if he comes down and testifies.
Did your client tell Mr. Bachner that he had actually fudged that he had actually changed the numbers on the Uber receipts at Goldman Sachs?
He did, Your Honor. Well,
but he said that he didn't think Goldman Sachs knew that he had done that, right?
no, that wasn't said. He testified that he deleted the origin and destination points.
Changed them.
Oh, no, deleted them. Just didn't change them, deleted them.
I thought he also said he changed them, but go ahead.
But he said he never conceded it to Goldman Sachs. And he's maintained throughout his deposition testimony in 2 separate depositions in this case that he thought it was an acceptable practice at Goldman to streamline expenses.
Thank you.
Your Honor, there are a few things I'd like to unpack real quick. As an initial matter, counsel noted that Mr. Porter was never asked about the issue concerning an arrest. That is correct. He was not asked that as deposition, but I note that he never provided an affidavit in this case stating otherwise, and we have Mr. Bachner's direct testimony is the only source of information we have in the file relating to that. Now, counsel also noted that there are 8 cases that indicate in their belief that plaintiff could have received a lesser charge or a lesser bar, lesser sanction. I know that those 8 cases involve falsification of records.
Right, I read I think it was Denise Olson or something like that.
Correct, and Denise Olson specifically.
That was the one I think that Floyd actually sent to
Correct.
to Mr. Bachner.
Correct.
Right. And that one was not on point, totally different.
Correct. Well, Olson was a conversion case,
Right.
and the plaintiff or the representative, Ms. Olson, argued that she should be under cases cited specifically by plaintiff, the Leopold and McCartney cases, because they were falsification of records cases, and the SEC rejected that argument and noted that because Ms. Olson was charged with conversion, and conversion mandates a bar, falsification of records cases are distinguishable because they don't mandate a bar. And here, there's no question that Mr. Floyd at all times advised Mr. Bachner that, and as well as Mr. Porter, there's an email from Mr. Floyd to Mr. Porter in which he forwarded a copy of the Olson case as well, and he said, this is the outcome of conversion cases. Mr. Floyd at all time told Mr. Bachner that FINRA was going for conversion. That's unrefuted. They never got any testimony from Mr. Floyd or anything. Yes, Your Honor. Sorry.
I was just going to say the non-cooperation was a strategic move. They chose to pursue that.
Correct. So that Mr. Porter would not
didn't have the
appear and
conversion.
testify and have to make admissions on the record as to the wrongdoing that he engaged in while he was at Goldman Sachs.
Thank you. Thank you both. U.S. Bank v. Mauve Hotel. Oh, you're back.
Yes, I'm back, Your Honor.
Same client.
May it please the
Yeah,
court.
we were saying that. We thought it was the same thing.
May it please the court, I represent the appellants in this matter. Appellants are appealing from an order, motion court which granted respondent's summary judgment as cause of action for foreclosure of a commercial mortgage. The order should be reversed in this case remanded.
What additional discovery? What additional discovery would assist you, or how would additional discovery assist you?
Your Honor, we never had any discovery. Could I address? Let me address the points. Just on the record, why they're tribal issues of fact, just on the record. So the respondent is not the original lender. It's not the alleged transferee of the original lender. Instead, the respondent is the alleged transferee of the alleged transferee of the original lender. Whereas here, a plaintiff is seeking to foreclose a mortgage. It was a subject of multiple alleged prior transfers. That plaintiff is required to
There's a
come.
representation by the plaintiff's lawyer, is there not, that he has the original note with an allonge stapled to it? That's not sufficient to...
No, I mean, he doesn't know where the document comes from. He doesn't have personal knowledge of the execution. We have to go back to the beginning of the chain of title. The documents were allegedly transferred from Cantor Commercial Lending.
And the Bittman affidavit doesn't provide that?
No, because Mr. Bittman, remember, there are two sets of transfers from Cantor to this other entity with this peculiar name of CCRE Loan Seller 2 Series DM, a segregated series of CCRE Loan Seller 2 LLC. And from that entity to the respondent here, Mr. Bittman does not claim to have any personal knowledge of the alleged transfer from Cantor to Loan Seller, and he does not claim to have personal knowledge of the record-keeping practices and procedures of either Cantor or Loan Seller.
But he has, he stated personal knowledge of receipt of the trust file, that the file contained the note and the mortgage with the allonges, which were stapled to the original note, and that he kept this in his possession, remained in his possession.
Your Honor, he does not have any knowledge.
But he says all the prior records are incorporated into LNR's own business records. Which
No,
they've
he
been
does not. No,
relying
no, no. He
upon
doesn't
as
say
business
that
records.
Loan Sellers are Cantor's records.
He says what? I'm sorry.
He's not. He can't testify as to the records of Cantor or Loan Seller. Just because they're sitting there doesn't mean that they're. No one has authenticated any of those documents.
And so additional discovery would be necessary to show what?
To find out, well, were the documents properly transferred from Cantor to CCRE? Furthermore, there's also documentary evidence which creates tribal issues of fact as to the chain of title by respondent, as a document filed with the SEC directly controverts respondents' allegations concerning the chain of title to the note and mortgage. According to that document, a mortgage loan purchase agreement, Cantor sold all of its interest in the mortgage loan to an entity called Deutsche Mortgage and Asset Receiving Corporation, and Deutsche was supposed to transfer that mortgage loan to the mortgage trust, of which respondent is a trustee.
I'm sorry if I'm fixated on the discovery, but there was a briefing schedule, was there not, or some type of order by the court that you were to, that you did not engage in terms of discovery?
No, Your Honor. There was some discovery, but the respondent didn't provide any discovery prior to the making of the motion.
Did you respond though?
Excuse me, Your Honor?
I'm sorry, none was turned over? Nothing was turned over?
Not before I think they turned something over on the day they filed their brief, the day they filed their motion. Didn't have an opportunity to follow up on that, didn't have an opportunity to take anyone's depositions, nothing. So the court was supposed to have a scheduling conference, didn't do that. So with regard to that mortgage loan purchase agreement, that's at odds with the respondent's allegations concerning the chain of title here. Now, we all know that these securitizations involve an avalanche of paperwork and squadrons of lawyers. So it wouldn't be a difficult task to have someone involved in that securitization explain why this mortgage loan purchase agreement appears to be inconsistent with the respondent's allegations as to the chain of title. But no one testified as to that. So you have this discrepancy between that document and the respondent's allegations.
Thank you.
Thank you, Your Honor.
May it please the court, Scott Truss for the respondent.
So what's your response to counsel's point that you don't know what happened before LNR took over? You don't know that it was properly signed or executed?
So the single most popular defense in these cases is lack of standing.
Right.
When we file the complaint, we know we're going to see it.
We know?
We know we're going to see it as a defense. Right. It's every single case. Right. So in order to deal with that, my practice and it's in my affidavit, is I request the original file from the custodian for the securitization. They send me the original file. I look through it to make sure that the original loan documents are there and that the allonges are there and stapled to the note. Then we file the action. I believe, there are many cases on this subject because it's such a popular defense.
So if you have the original file and it seems to be in order and the business records of this mortgage, you have a right to rely that there's a presumption of regularity, would you say?
Yes.
And that provides you with standing where you have the original note and allonge stapled to it.
Yes, and I believe there are many cases that so hold. So what we're talking about now is one of the two ways that you can establish standing. Physical possession of the original loan documents with the allonges attached to the note. We have that. I brought the original note to the oral argument. I showed it to counsel. I offered to show it to the trial court. The trial court says, no, I don't need to see it, as long as counsel saw it.
So you've met your burden by producing the original, and if defense wants to create an issue about it, the burden then switches to them to show that there's something untoward about the execution of this note and allonge.
Yes, yes. So that's one basis for demonstrating standing. The second basis is there are two assignments, one from the originator to CCRE loan seller, and then there's another from CCRE loan seller to the plaintiff. They're in the record. They're recorded assignments of mortgage. We think that we've demonstrated through putting those into the record assignments in accordance with the case law. So we've demonstrated standing not just one way, but two different ways. In terms of your question on discovery, I don't think, first of all, the record needs to be clear on this. It's in our papers. There were requests for documents. It was electronic discovery. Unfortunately, it takes a little while to comply, but we did collect all the documents and produce them, and we offered, and this is in the record, we offered to adjourn the response time on the opposition papers until after he had a chance to review the documents we were producing. He declined. I think he declined because he felt he was better off being able to argue to the court that I didn't have any discovery. I don't know what's inside his head, but I did offer to make it right. I believe that given the record in this case, no amount of discovery is going to change the basic fact that I had possession of the original loan documents at the time the case was commenced, and that we've got recorded assignments in proper form as part of the record here. So we think that Justice Reed properly granted summary judgment in this case, and we ask you to affirm. Thank you.
Thank you.
First, Mr. Tross's assurances carry no weight because he has no idea where those documents came from. He didn't even identify from whom he got the documents. He said, I got them from the custodian. Who is a custodian? Where is any evidence? Is someone saying, yes, the documents we gave to Mr. Tross are, in fact, the authentic original documents? No one has said that. He's not in a position to testify as to the original transfer from Cantor to loan seller. By the way, the assignment from Cantor to loan seller, not recorded. Now, Mr. Tross suggests, and respondent suggests in its papers, that there can't be any triable issues of fact concerning standing because it asserts it has possession of the note and because a copy of the note was annexed to its papers. Well, they're wrong.
Who signed the note?
Excuse me?
Whose signature appears on the note?
So on behalf of Mave Hotel Investors?
Yeah. Isn't it your client?
Yes?
So when he produces, he says, look, this is my original file. I find these documents in there and it has your client's signature on it. So you mean he has to do more to establish the authenticity of that signature? And the burden doesn't pass to you to say, that's not my signature. I never signed it.
Your Honor, they have the burden of proof. They have to establish a chain of custody for those documents. They have to establish it
Look,
went
this
for
is the
Cantor,
original. This is the
alone.
original loan folder.
Says who?
He says he received it from
The
the
custodian, he says he received it from some unnamed, quote, custodian, close quote. Who is that? Where did that person, where were they? Where did that custodian get it from? His testimony is not, that shouldn't carry any weight at all. I'd love to come in and...
We're dealing with the note which has your client's signature on it.
Yes? They have the burden. They have to show it was properly transferred at every step of the way. That's the case law. That's the burden they have. And it shouldn't be, if it, I can't understand why it's so difficult, because you've got lawyers at every step of the, allegedly you got lawyers at every step along the way. Why can't they come forward and explain, yeah, this is exactly what happened?
Thank you.
Your
609 Real TV, New York State Division of Housing.
Good afternoon, and may it please the court. My name is David Cabrera from Bora Goldstein, Altshuler, Nahans, and Goydell, and we represent the appellant. This case is about fundamental fairness and due process. The appellant who invested...
You know, you certainly raised some interesting and seemingly perhaps even valid points in support of your position. But what do you do with the case such as matter of 440BA LLC versus Division of Housing and Community Renewal? Haven't we already taken a position, hasn't this court taken a position adverse to that which you're advocating for here?
No, Your Honor. And to borrow a phrase from an earlier appellant, Mr. Metz, it's apples and oranges. In 4040 and in 101, they actually granted an increase pursuant to the change in the law. So they received less, it's temporary. Here, the application was filed, it was pending for 6 months, and it was denied. And when you look at the statutory interpretation, when something says it's effective immediately, it's normally giving prospective, effect. And what you should ask the state is, why did they not follow precedent going back from this court in Storch, where there was a change with respect to MCIs, applications had to be filed within 2 years of doing the work, and what they did there was they said, okay, if it was filed for more than 2 years, that's fine, because the law had changed, your application had been filed prior, but we'll apply it going forward. Our position is that if this court were to remit this back to DHCR, for them to make a determination on the merits, not to just deny the application, they just got rid of their backlog. Oh, let's get rid of these. If you were to send this back, and now they applied 4040, and my client received less of an increase, and somehow we ended up back here, then yes, then that would be 4040, because at that point it was applied.
What I think my colleague was raising here was the argument you're claiming that because you filed your MCI in 2018 and the HSTPA Part K, which has the provision you're unhappy with, namely the 35% rule that would exclude your client from getting the MCI for the 6 apartments out of the 26 apartments in your building, that it should have no effect. And what I believe the President said here is that this law would apply to a pending application that may have been filed before the HSTPA, but will be subject to the provisions of the HSTPA when the application is finally processed. I believe that is the weight of that precedent. Very different fact pattern than what you're describing here. Do you disagree with how I described the principle in that holding?
Yes, because this is about fundamental fairness. When they did the work, invested, completed, filed the application, they were entitled to that, at least have that application processed.
Well, it
Now,
was processed,
you're
sir.
asking-
It was processed. Your issue is, because I filed in 2018, predating the HSTPA, I therefore should not be precluded or subject to the 35% rule restriction that was newly enacted in the Part K provision. That's your provision.
Yes, we
Is that fair?
Yes, we are arguing that.
Okay.
However, 4040 did not address the 35% rule. It was addressing.
You know, I think you make a fair point, but when 4040 says when the HSTPA was enacted, petitioner had no vested right in a future MCI rent increase or in the more beneficial pre-HSTPA law or regulations, which is really what you're looking for here. And in the face of that, it seems to me that, you know, it may take the Court of Appeals to give you relief if speaking for myself. But.
Right, and it says, we said in 4040 that Part K's amendments were effective immediately and applied to any determination issued after the act's effective date. So it would seem as if we're bound, that this court is bound by 4040.
And what we have argued in our brief, because I see that the light is on, is that that language under these facts implicates the due process and equal protection arguments. I'll respond, if you would like, I can respond to any other questions or wait for rebuttal.
On rebuttal, thank you.
May it please the court, Kwame Akosa for the Division of Housing and Community Renewal. I want to first start with 40.
You know, I think counsel makes a fair point. I mean, didn't they spend hundreds of thousands of dollars here in improvements and every expectation of getting an MCI for it? Mm-hmm. And at the time they did it, the law would have provided them with an MCI. Comes along this amendment and says, well, we don't care what you did before. Mm-hmm. The law has changed, and even though at the time you made those expenditures, you would have been entitled to it, we're not going to give it to you.
Your Honor, that
fact... It's on its face something which is really hard to accept as a matter of simple fairness.
Well, Your Honor, on its face, that fact pattern is what occurred in 4040BA. And so my friend talks about a part of 4040BA that wasn't really at issue in that case. That case was about the group work ban. This was a ban on categories of improvements that were no longer eligible for MCI increases. In fact, the group work was done in every unit of the building, and there was that work that was done, it was in bathrooms, was not eligible for any increase. And it's the same sort of effect that the 35% rule has here. So I just want to dispute the contention here that 4040BA is not preclusive of the arguments we're hearing today. 4040BA directly addressed a situation just like the 35% rule, complete...
I think there can be little question that it's a problem for his position.
Yeah. Thank you, Your Honor. And so I would also specify that the statute itself there's nothing in the statute that gives rise to an inference that the legislature intended for this rule, the 35% rule, to be treated any differently than the group work ban at issue in 4040BA or the changes in the formula in 101 East 16th Street. And then just briefly on the undue hardship issue, Your Honor, this argument could have been raised in the appellate review process, but it was not raised. The provision that my friend cites to about undue hardships because of changes in law was in existence at the time. It's been around since 1987. They could have made an argument about how the change in law has caused them an undue hardship, but they chose not to. And there's also a provision of the Rent Stabilization Code that would have permitted DHCR to consider that argument, even though it was not raised the initial the initial MCI application.
And because the statute says effective immediately,
Right.
that's the time when you began considering the 35% rule with regard to rent-stabilized apartments.
Yes, Your Honor. So for every MCI determination that was made after the effective date, that was applied. And so that was the essential fact pattern in these prior two cases. We have individuals who have made their improvements before the change in law. They filed their application before the change in the law. While the application was under consideration at the agency, the law changed. Once the agency got around to determining their eligibility, they applied the new law. If there are no further questions, we ask that you affirm.
Thank you.
Mr. Cabrera, could I ask you something? Can you point to any appellate precedent that gives an owner a vested right to an MCI increase?
I cannot say that there are cases that say that there is a vested right, but there is, okay? If you have, what happened here is DHCR made a policy decision. Usually when the legislature says that this is effective immediately, it's applied prospectively. And my friend did not address DHCR's past policy in Storch, where there was a change, and they did not get rid of a backlog of cases where had been filed more than 2 years prior, because you're asking someone to respond to something tomorrow, right? That happened yesterday.
Point of information, that statute of limitations, if you will, that administrative limitation, that was an internal administration regulation. Was it based on a rent stabilization statute?
It was internal, and from what I can see, it was.
I'm very familiar with policy statements and operational bulletins. The question I'm posing, sir, is that rule that you described about the window when you should be filing MCIs close in time to the work completed. That's internal. Unlike, just bear with me, is it a statute? Is it a provision like the HSTP that was enacted that forced the DHCR to amend its rule to do that?
The 2-year filing requirement is regulatory, and I cannot remember under this, here in front of you, whether it's also in the statute, because it was from the 80s, right? But that was regulatory.
But that would be a little different than having a statute such as the HTPA telling the agency this is what you must follow.
What I think the difference is that when something says it's effective immediately, it's for the legislature to provide clear direction, and it's always been done prospectively. Here, I believe they ignored prior precedent, which this court has approved, but also applied it in a way that was really unfair to not only this owner, who, this was not about anything excessive, or it was an upgrade to elevators, videos. And to say that you should pass that along to your unregulated tenants really doesn't hold water.
Thank you. Thank you both.
Thank you, Your Honors.